Senegal, China, Morocco, France, Netherlands, and many other countries. We have made it possible to bring Ghana to the world. We have brought small and medium businesses closer to their customers across the regions in Ghana with our SME support facilities. We have brought relief and smiles to the faces of families with our employee personal loans. With our cutting-edge technology and digital support, we take the burden of complex thinking off you, making life simple. That is who we are, as close as a partner. Bank of Africa. We are indeed the African bank with the global reach.
So, Charlie, the deal there, I almost get her.
Syntax pipe, as tough as it can get.
You get so solid with your back, sorry. Oh, what you was that thing? Hey,
What the cat never won?
Hey, now I'm pipe.
Between the fire and carbon.
Hey, madam, pipe menu.
I have Syntax pipe. Me tono, Omukacham send a warden pa. Say a fee, say a foam. The other pipe we be a yen gum.
Syntax pipe.
Why a leaky?
Come, madam. From today, Syntax pipe in my pipe. No 2 ways.
We need a pipe ben abe you see.
SINTEX pipe.
Syntax pipe.
In a carry water. No hala.
Hi, now let me share my wildlife experience with you at Safari Valley Eco Park.
Welcome to Safari Valley Eco Park.
Our electric shuttle pulled up and in no time our tour began. We were surrounded by wildlife from the moment we entered the Eco Park. We were greeted by experienced tour guides who took us through orientation and how to better enjoy the experience. Watch these animals roam freely in their natural habitat undisturbed by our presence. We saw zebras, sable antelope, brown cranes, mara, silky chicken, nyalas, Shetland ponies, and so many animals I just couldn't keep up. Our tour guides taught us so much about the wildlife, their behavior, and how to interact with them. I even fed them. We also went fishing on a man-made canal. Then we took a break to have lunch in this serene environment. All this amazing experience for this price for adults? This price for teenagers. It's a bargain. As the sun began to set, it was time to go back home, but not before dinner by the campfire. It has been a thrill of a lifetime, and I can't wait till my next visit.
Safari Valley Eco Park, bringing you closer to nature.
Big Chef Season 4 finale. Who wins the ultimate? A whopping sum of 15,000 Ghana cedis cash prize. Some products from sponsors, an enviable plaque, and bragging rights for her school. Sewa, Graceam Academy. Nicole, Rising Sun Montessori. Mona Lisa, Alpha Beta. Bubune, Association Community Model Basic School. This will be the fiercest culinary battle of the year. Join us at the Joy FM car park on August 10, 2025, live at 4 p.m. on Joy Prime.
Welcome back. This is Newsfile, it's your most authoritative news analysis platform, and here on Newsfile we put Ghana first. And my guest this morning, Victoria Bright. You call her Vicky Bright, international corporate lawyer and entrepreneur. Kwame Boafo Akufu Esquire of Ekropong Ekwapim, here in the studio, live in the studio here on Newsfile. Bright Simmons is Honorary Vice President, Imani Africa. He joins us via Zoom. Abraham Amalba is Director General, National Road Safety Authority, and member of the NDC Legal and Communications team. Hobna Boateng is MP, Ejuso, and Deputy Ranking, Security and Intelligence Committee of Parliament. And Oliver Bakavomawo is Constitutional Rights and Policy Strategy Advisor at Democracy Hub. They have one.
Well, this
you have been quiet for too long. You want to say.
Well, this
you have been quiet for too long. You want to say.
There's no question that there's a change of tone, at least in terms of what the government is reporting. But also a lot of things which, I mean, thanks to the work of Erastus, we can also agree that there are failings in several aspects. There are also failings in terms of the own government's own commitments regarding the repeal of LI 2462, the government's own considerations about the use of the gold board, and in terms of what revenue is coming in, about tracking and be able to determine what is coming from Galamsey sites, or whether or not now we are state sanctioning the purchase of gold that is coming from Galamsey sites is a matter of concern. The treatment of foreign nationals as vis-a-vis Ghanaian nationals is also a question of concern. So there's a host of issues, which is, and I want to be clear, it's also about mobilizing public support to keep the pressure on. So it's not necessarily always a question about pointing out failures, but also letting the government feel the sense that there's a huge public demand for more action.
And when in September are you doing this?
On 21st of September.
21st of September.
Which has kind of become a pilgrimage, Nkrumah's birthday.
The last time that date was almost thwarted, you didn't get it. And you are hoping to gather around the Jubilee House again?
We haven't put out an official venue yet, but we are still thinking through.
All right. So good morning, ladies and gentlemen. Thank you so very much. And good morning, Kwame. Thanks for making time to join us. We have very serious business to deal with, but we want to begin with picking very brief comments, a minute or two from our guests about recent developments. This government is only 7 months old, but the GJA, Ghana Journalists Association, tell us that the annual average numbers of assault on journalists doing their lawful, constitutionally sanctioned duty, which is about 12 assaults. This year, we've already exceeded that number. We're doing about 14, we understand. And so we want to understand what exactly is going on. At the Ablikmanoff by rerun, there was such brutality meted out to not only journalists, but also, other persons who were there to cast their ballot. And Akwatia is in sight, and there are fears that things may get worse. But Carlos Kaloni, Joy News reporter, was at McDonald's, one of McDonald's warehouses where there was a demolishing exercise. All he was there to do was to cover the demolishing exercise. He was interviewing an eyewitness of the demolishing exercise a day before he went there. And soldiers pounced on the eyewitness, whipped the eyewitness, they beat him, they assaulted him, and also assaulted Carlos Kaloni. So what exactly is going on? The GJA has spoken, Media Foundation for West Africa have also spoken, the president has spoken. Let's hear them briefly, and I'll hear my guests quickly before we go to Unibank and OSP chasing SML disguised at the airport, as well as whether or not the Chief Justice's hopes of an intervention from the court have been dashed.
We demand that the Ghana Police Service and the National Security provides a public explanation for the arrest and detention of Carlos Kaloni and his cameraman. Additionally, we request the immediate release of any findings or internal reviews conducted regarding the uniform officers involved. If the Ghana Police Service fails to act decisively within the next 7 days, as already stated, the GJA, in consultation with key stakeholders, will announce a nationwide media blackout of all police activities. We will instruct our members to withhold coverage of police events, refuse participation in police press briefings, and suspend all forms of editorial engagement involving the police. The data available to us, the information and records available to us indicate that the average attack on journalists every year stands at 12. So if we have already recorded 12, even before the end of the 7th month, it is very, very scary and alarming. A detailed update on the status of investigations into all reported attacks against journalists across the country within the past 7 months. We expect these demands to be met within 7 days from the date of this statement. And I want to reiterate, I want to take this again. We expect these demands to be met within 7 days from the date of this statement.
It really is very heart-wrenching to see these things happen. And it's just because this impunity goes unpunished. You know, we have several examples of these things that happen. And then the last one that happened just before this, what happened at Ablekuma North? What has happened to that policeman? We are told of interdiction, and it's all clouded in secrecy, and nothing happens. That there's the situation of even your colleague who was beaten up by the police at the police headquarters. What happened to that? You know, the police told us that, you know, there's no CCTV footage of that. So it is important that in this one and in the rest of them, we demand transparency from the authorities in terms of the way the punishments are done. And so the military, yes, it's good that the statement has been issued, but what happens after today, we need to be kept, you know, in the know. And we should get to the point where, you know, just as we did in other cases, especially multimedia, where you took civil action, some action has to be taken. There are some of the cases currently, like Latif's case, there is one of the Pius's case who was also beating up during one of these elections. We need to be taking these cases. If it won't be handled in Ghana, we should be going to the ECOWAS Human Rights Court.
I think that what happened yesterday is completely untenable. It's a deeply embarrassing one to see men in uniform, our military men, behave the way they did yesterday. And I think that we are also witnessing a very, very worrying pattern of some of these actions in the name of national security operations. I think over time we are hearing national security matters on issues that are just completely embarrassing. And the earlier these things are stopped, the better. I have
to condemn in the strongest terms the recent incident involving the manhandling of some journalists by our security personnel. Such conduct is unacceptable and will not be tolerated. I've instructed that the incident be thoroughly investigated and that the officers involved be sanctioned accordingly. As a card-bearing member of the Ghana Journalists Association, I will not preside over a government that abuses or intimidates journalists in the lawful exercise of their duty. A free and responsible press is indispensable to our democracy, and we must all work to protect the media. I'll soon convene a meeting between the heads of the security services and the leadership of the GJA to plan a program to orient our troops to recognize the media not as enemies, but as partners in development.
And the demolition started on Tuesday, continued on Wednesday, and this occurred. Yes, so Vicky Wright, what do you have to say about the incidents and what we ought to do to stop them?
Well, I mean, clearly, Samson, this is totally unacceptable. We cannot have a society where journalists are just being beaten up, slapped, etc. We saw what happened in Ablekuma North with the multimedia journalist, the young lady, and she was, you know, slapped and manhandled by
the GH1
police
journalist who also got a
or the
hefty slap.
Exactly.
Right.
So we have
but the police officer in that event was interdicted.
Right. So we need to follow that through. I mean, he's been interdicted and you know. So we need to know what we've been told what's happening. We need to know when the conclusion comes and what that conclusion is, because it's only at that point that it will act as a deterrent. We can't have policemen beating people, slapping people, and the military now wading in and also beating people up. What were these journalists doing? And let's be clear. I mean, journalism, the job that journalists do is a fundamental pillar of our democracy. And it's necessary. If we're going to call ourselves a responsible democracy and we're going to be respected as such and, you know, tick all the boxes in the international indices, this is a very significant part of that. So it's not something that we can toy with or pretend we are doing. And I'm so happy that the president came out and condemned it in no uncertain terms. A lot of these security forces hide under the banner national security. And I think it's being abused. That whole notion and concept of national security is now being stretched to a point where, you know, it's becoming an avenue for abuse, for people to just do what they want to do. And we need to feel safe and secure, not just journalists, but all of us as Ghanaian citizens. The police are there to protect and serve us, as are the military. So when we get to a point where we are now afraid of them, then something has seriously gone wrong fundamentally with our society. I mean, it's just a couple of minutes comment, so I'll park it here. But it's totally unacceptable, and the perpetrators should be dealt with in the strongest form. We have now come to a point where examples must be set to act as a serious deterrent going forward.
Kwame Boafokufu, the military says that they are going to conduct investigations into this, and then we'll hear from them.
I like to take the matter past the issue of journalists. I think that journalists cannot be safe in this republic unless law and order in the republic is maintained for each and every member of the society. We have come to the point where people now take the law into their hands for the resolution of every simple dispute. For example, when there's an accident on the road, people no longer wait for the police. People will attack the driver. Most of these accidents between cars and motor riders, for example, result in grave collateral damage subsequently. As a society, I think we're beginning to lose the plot to the protection of the citizens. And it is that sore which is now festering into other sectors. This issue of attacks on journalists, to come to the substantive issue, is very dangerous for our democracy, because we are now headed in a place where persons who will broadcast and throw a light on persons who are to be accountable to us are now being suppressed by fear and threat, and in fact, implementation of assault. I think it's painfully unfortunate, and that the call by the president, while it's a good call, must be seen through. My learned friend on the other side spoke about the fact that the president has spoken, but what is next? We all await what is next, because unless implementation and examples are set, people will not change, and this assault behavior will continue. It weakens the state and the image of the republic in the eyes of our neighbors, and we should do better. But we should not forget, law and order is not just for the benefit of the journalists, it's for everybody, from Accra to Gambaga, from Kita to Sishuyoso. It's important.
What's your answer when you hear suggestions that the journalists and the eyewitness may have done wrong because this place had become sort of a security zone? They were doing an operation there, so you shouldn't have been there in the first place?
Trespassing has its remedies either in the criminal domain or in the civil domain. It has never been the Republic's law that a person who is trespassing and when detained has to be assaulted by men in uniform. We've not gotten there. If it becomes an entrenched position, then we are in trouble. But that has never been the law.
Okay. Abraham.
Yeah. The military in this matter has not covered itself in glory. I saw the beating and I was shocked to my bone marrow, because I thought that the police should have been the one supervising this work and not the military. And I'm happy that the president has, in his own words, ordered the military to investigate the matter. And I'm told, and I can inform you, that the military men are in guard room now, and investigations are going on. But the larger picture is that...
That is to say they have been interdicted?
Because I'm told that the army don't have interdiction. What they have is to put you in the guard room.
Yeah. So that's
what I'm told.
That's synonymous to interdiction. So to speak,
that's why I was so careful not to use the word interdiction.
Okay.
So, but the larger picture is that we need to look at the curriculum of the training schools of these state institutions. Do they have subjects such as democracy, good governance, and media law? Are they taught? I'm asking questions. Because they are operating in a democratic setting, and you need to train them to be, amenable to the democratic principles. So
they definitely thought about democracy.
Okay.
They have it.
Okay. So you need to ensure that these security agencies comply with the democratic setting that we have. If you have curriculum that is old-fashioned, when they were a force, that's the police I'm talking about, or when they were in the colonial era, then you will see some of this. But I think that moving forward, this should be the end. We should need to draw a line. There are remedies. If you have unruly journalists or unprofessional journalism, there are remedies to it. You don't whip people. You don't take cane to whip people as if they are animals. I think that should be said.
Honorable, once again, and we are having this discussion, and we're saying the military, the security, often they have been guilty, supposed to provide protection, and they end up being the ones who are perpetrating the violence. But is it not also the case that it is perhaps the few errant ones amongst them that are doing this? But when we're discussing it, we paint all of them with the same brush.
Yes, I agree with you, but it's still a concern. Whether you have a few, section of the security agencies, perpetrating what would not be in the tenets of their job, the effect is still the same, especially when it comes to journalists. It is one very sensitive item when it comes to even international ratings as to the maturity of our democracy. Anybody observing, internationally and sees that journalists are being beaten in a jurisdiction. And obviously what it means is that you are not serious with your democracy. And that is why we should begin to see it as a very serious matter. Also, when we have come to a certain consensus that in this democracy that we are practicing, without the media, I don't know what we can do with our democracy. If we sit in parliament and pass all the laws and do all the scrutiny and oversight, the executive does all that it has to do, and then there's no, what we have come to describe as the fourth realm, to take it out there and to break it down for the consumption of the general public. And also other areas of unearthing what the people need to see. Then our democracy hasn't come to where we expect it to be. So an assault on journalists is like an assault on any other arm of government, which shouldn't be taken lightly. In the larger context, and because most of these things are perpetrated by people in the security service, and my senior also did indicate the worrying emerging issues about national security. When you read the national security law, you do not see a contemplation of a weaponized group of people. I don't see that to be the intent of the law, especially even in modern times where national security is now about human security. It is about research. It is about helping government with timeous obtain of intel. It is not about people wielding guns. And, well, I was going to say something, but we are on TV. I will not say it. I happened to be at a police station where an officer of national security was asked to write his name, and it became a problem. And he was wielding, yes, he was wielding gun. So you could see that he has no form of education whatsoever. And these are people wielding. Recently, you may have heard
I don't
about
believe this. I don't believe
I'm telling you, I was there. You may have heard about the issue with the Forestry Commission, where people had gone there in the name of national security to lock up estate agencies. So we have examples of states that went into that kind of rogue national security operations and its repercussions ultimately on the democracy.
Okay.
So we should look at it in that wider context, and deal with it as we should.
Thank you. Now, Oliver, there are people who say that they are irresponsible journalists around the place. They are mercenaries these days. A lot of them around town. They are just misbehaving, and some of them, their actions can plunge this country into trouble. So if they are getting some discipline sort of from the security agencies, why are we complaining?
I think that discipline is healthy for every democracy. The question is whether or not it's the kind of discipline that a democracy contemplates. It's never been within the contemplation of our democracy and the things that we say we abide by for gun-carrying individuals to descend onto the streets and attack whoever they think is indisciplined. It is not a great show of discipline on yourself, even, you know. And one of the things that I think I want to be able to emphasize as well is it's not a rogue individual or one or two individual problem. It's a culture problem. When you go from what happened to Sam George to what happened in Sherman, and there's so many instances in terms of what happened to Lateef Idrisu, and what is happening now. They are not even worried where their camera is there. Like, they conduct these things open on camera, tells you that there's absolutely zero repercussions within the institutions themselves as to how to be able to reform conduct. In fact, when it happens so many times, I am yet to see instances where people have said that, you know, the institution took this up and that conduct was reformed or these people were punished in a particular way. It doesn't happen. They close ranks and protect each other. And you have to try to find, you know, justice in the courts, and even that takes forever. So how to be able to ensure that people are disciplined in terms of those who are within our security services, it's a matter that requires reflection beyond, you know, there's conversations about creating an independent commission that looks at violations because they themselves are not interested in how they go about it. We hear interdictions all the time. I know of interdictions where once it's announced in the media, a couple of days later, the people are allowed and brought back to work. So I think we have to deal with it as a culture problem within the institutions themselves and take it from there.
All right. Thank you. Bright, are you with us?
Yes. Can you hear me, Samson?
Yes, Bright. Very quickly, then we go on to the Unibank's subject matter.
Yes, I think after the condemnations, all your guests have been uniform in dishing them out, and I'm not going to pardon it. But there are two very important dimensions that I think probably is noteworthy. One dimension is in relation to the specificities of this particular case, where what we saw was clearly the act of soldiers. And I think we have to, as a country, decide whether or not the use of soldiers for activities that typically the civilian law enforcement agencies and the police are best suited for is still right. And if it's indeed right that we need soldiers for whatever reason, and this must be a matter addressed by policy as to why in certain instances you need soldiers as opposed to using the police, then we have to confront what has become an unspoken culture in this country, unspoken principle in this country, that we don't prosecute soldiers in civilian courts. If you've noticed, in many instances where soldiers have been identified as committing some of these atrocities, it's been really difficult for the high command to pass them on to the civilian courts for prosecution. Even though, if you look at Armed Forces Act very carefully, it's not defined in such a manner as to override the general criminal law. So we had a situation where people had to go to the ECOWAS court because even after Shraj had made certain recommendations, it wasn't pursued. I'm talking of the Stella Kubaji matter. The matter went to the ECOWAS court. The ECOWAS court made a pronouncement as far back as last year, March, if my dates are correct. And up to now, the Ghanaian authorities have not enforced the judgment. So those soldiers have not been prosecuted. This was a case where a woman and 4 minors were brutalized. So we have an unspoken principle, is my view. Now the question is, do you want to set policy that clarifies this? Even when we have military justice, being kicked into effect, we don't really hear whether or not they went through court martial or what exactly happened. So this is a matter that I think we all, as elites in this country, as people that are committed to public affairs, as people that are observants, have to decide, are we going to pursue this or not? Because we keep talking about it, but there's very little done to actually push justice. And the last point I will make is that beyond physical attacks, we're also seeing the use of intimidation in other forms, use of frivolous lawsuits, which has made it very difficult for journalists to do their job in this country, and withdrawal of advertising. So many of these abuses also affect the ability of journalists to do their job. So I think the GJA should move beyond just talking about physical assaults to all the factors that are constraining journalistic practice in Ghana.
All right. Thank you very much. A good friend of mine, Dennis Ejejumo, says that he's seen that many times I take suits against the institutions for human rights violations against journalists, but he believes that we should begin to do it a different way. Sue the individual officers, identify them and sue them so that they are held personally liable as well. Maybe when we begin it that way, we will also begin to see a lot more accountability. Right. Thank you very much for your comments on this subject this morning. Now let's go to the Attorney General, Dr. Dominic Ayine. He last week issued a statement announcing that Dr. Kwabena Dufo and 7 others were standing trial over the Unibank collapse, or the revocation of the license of Unibank, were free, and that they had a structured payment process for what they were liable for. So we start with you, Bright. You're going to make a presentation in some 15 minutes, and then I'll come into the studio. We'll spend a bit more time also with Kwame Boafo-Ekofu, and then our guests will all join to share their views on this subject matter. But what do you say? You spoke too early when you wrote your article suggesting that the recovery so far would have been, or what the Attorney General is talking about, would be only 10% instead of the 60% that he said that he was able to obtain for the Republic. You think you spoke too early from the facts and the information that have now come to our, knowledge?
Not at all. And I think by the time I'm done with my presentation, it will be very apparent that some people have been having a different conversation from those of us that are talking about liability to the country as a whole versus the specific cost proceedings. And Samson, I'm very grateful that I have the opportunity to do this presentation. I'll start off by saying that, when you think of a bank, like any other organization, any other commercial entity, you've got assets and you've got liabilities, right? And for a bank, what confuses a lot of people is that the deposits that you go and put in the bank is not an asset of the bank. It's a liability of the bank. It's almost like a debt. It's a loan you give to the bank. And obviously, the bank then gives out loans, and those loans are the bank's main assets. Of course, the bank can also borrow money to on-lend, and if they borrow the money, that money will also be liabilities or debts. Let's just use that term, debt. And then their shareholders themselves to put in some money, because without significant equity as a shareholder, you're not allowed to start a bank in the first place. So that's the starting point. Now, the point about the shareholders putting in money is very important, and I will explain in a minute why that's so critical. For banks, you need shareholders to put in a minimum amount of money, which is not the case in many other businesses. And the reason is because banks have a very particular risk attached to them due to the fact that the money that we put there as deposits, when they lend it out, they do so pretending, so this is like a magical kind of thing, pretending as if that amount of money, even though it's a call deposit, I can come in and pick it up anytime I want. They make it look, they pretend as if that money is being given to them for long term, but it's not really long term. I can show up tomorrow to pick up the money. Yet they often lend it out long term, 5 years, 2 years, 1 year, whatever. So because of this delicacy around the way banks are structured, you need what we call prudential regulations to be extremely strict, otherwise you get trouble. So this is where we get into the Unibank matter. Essentially, the way banks have been structured as public utilities, because of the delicacy of the whole operation and the risks that are attached, banks cannot be run like any other business, is the point I'm trying to make. So we get into Unibank, which is a bank that, until 2017, actually until 2018, was regarded as one of the best banks in Ghana, one of the best growing. It was, very often on the Club 100, which is the list of most prestigious banks in the country. It had 370,000 individual customer accounts and over 400,000 accounts if you count the corporate and other accounts. $1.25 billion in assets. It's a big bank, essentially. And if you go to December 2016 and you look at the balance sheet of Unibank, absolutely nothing was out of gear. Everything seemed to be in place. It was a bank that was doing very well and seemed very profitable, as you can see on the balance sheet, in terms of the total equity way above the minimum equity that was then required, etc. What we didn't know until much later was that certain aspects of this balance sheet that you see was not actually what it is. Essentially, these audited financial statements that were published, it was also a listed company on the stock market, and therefore it had rules that it had to comply with. Some of that stuff was not correct. So I'll give you an example. Even though it was seriously on liquidity support, chronic liquidity support from the Bank of Ghana, that was not somehow reflected on its statement. So you wouldn't really see the full extent of its liabilities if you look at the statement. And certainly that situation worsened in 2017, where it moved from about 850 million Ghana cedis to over 1 billion Ghana cedis in terms of monthly support that it was getting from the Bank of, in terms of annual support that it was getting from the Bank of Ghana. On top of that, when you look at its regulatory disclosures, what it was telling the regulators, it suggested that its non-performing loans was just about 5.34%. This was December 2016. The truth, in fact, was that things were far worse at the bank than anybody knew, because its disclosures, what it was publishing in audited accounts and the rest of it, were not correct. So, for instance, as of 31st December 2017, the banking supervision department at the Bank of Ghana, based on the audits that they did subsequently when these matters came to their attention, showed that they had overstated the loans that they were publicizing by about 1.3 billion Ghana cedis. And that some of the loans that they had actually given out under the so-called other assets category, most of which had gone to their own companies that they owned, had also been understated by about 3.8 billion. And that customer deposits is actually quite frightening. Customer deposits balance had been understated by up to 2.3 billion. So in those days, that amount of money was in excess of $500 million. So there were about $500 million of customer deposits that they just simply were not disclosing to the Bank of Ghana. Later on, Unibank will suggest that part of it was due to a problem with their banking system. They had the terminus software, and they did a cutoff, and it caused chaos in their numbers, etc., etc. Whatever be the excuse, the truth of the matter was that we did not really know what was going on in this bank, even though it was an audit. It was a bank that was listed on the stock exchange. It was audited and was regularly supervised by the Bank of Ghana. It was later when it came under heightened scrutiny, the Bank of Ghana was sending people there almost every month to audit, that they begin to understand the real problem that was going on. Secondly, there was also significant activities, in this bank where, for instance, they had borrowed money significant from international banks like Afrexim Bank to achieve particular purposes and were using for something else, etc. But the key principle is this bank was such a big bank that it was systematically important. What that means is when you are looking at it as a regulator, you're not only looking at the bank in terms of its own situation, you're looking at the impact it can have on the entire financial system. And part of the reason was because it had exposures and etc. to other banks, some of which I've listed like ADB, GCB, etc. And therefore, Prudential Bank, for instance, was heavily exposed to it. And if you didn't manage Unibank properly, you're going to damage the entire financial system. So the question really here is that we had a bank, it had huge problems. Because banks are not like normal business, you can't just shut them down and walk away. The government has to step in and clean up after the bank. So my point is, how much has the country lost as a consequence of cleaning up after the bank in ways in which we could not have avoided? And then on top of that, how much of that money could potentially still be with the former shareholders? And therefore, what is the fair amount to recoup? This is a different question from the question that I think a lot of people are asking, which is what is the amount that the government was trying to get in court, etc. And I will explain why there's a fundamental difference between the two discussions in a minute. But the simple reality is that you simply have to go to the latest analysis of the balance sheet of Unibank, basically what it owned and what it owes, right? As of March 2025, that is the latest that is publicly available. So March 2025 is later than some of the court documents that I've seen flying around, which dates to 2024. So when you look at the numbers that have been, analyzed and assessed by the receiver, by that point, you come to the conclusion that we had a certain amount of money that as a country we put behind the attempt to clean up after Unibank. And that really is what we are looking at. So when you look at on this balance sheet that I'm just displaying, it's very simple. How much of the money that you can categorize as assets, which was money you can really rely on, was at Unibank by the time that it was transferred to some of its liabilities and assets were transferred to CBG. Because most people know that. Most people know that the government more or less took some of the deposits, in fact all the deposits, and some other liabilities, very few liabilities, sent them to CBG and some good assets. How much do we get when we try to clean up? And when you look at that figure, it's on this chart right here, which is from the receivers. It was literally about 711 million. But the critical point is that when you look at Unibank's balance sheet, it tells you what it borrowed in terms of deposits, the money that people went to put there. It borrowed from other banks, it borrowed from the Bank of Ghana, and what it bought with what it borrowed. Because when you, in a business, it's very simple. You take money from other people and you invest it into assets that create money. So what you borrow, it's in this case of a bank, is the deposits people put there, it's what the Bank of Ghana gave them as support, it's what they borrow from other banks, and then they must use that money to buy assets, which then generates money. What are some of these assets? Loans you make is a very good example. Treasury bills you buy, etc. So when you look at the proper assets that were transferred to CBG, and this is all data that has been analyzed as of March 2015, there's only about 711 million that went to CBG. The rest of it have to be adjusted. And when you adjust and you look at the impairments, the money that we can't find, the money that we can't trace, etc., etc., you come to the conclusion that as much as about 7 billion Ghana cedis. Remember though that this is 7 billion Ghana cedis frozen at 2018. That point will be important. I'll come back to that. Nearly 7 billion cedis could not be traced or was not available to hand over to CBG. And somehow, in different ways, this country has absorbed that loss. How did we absorb that loss? All the deposits that you had in Unibank, over 4 billion, which is about $1 billion at that time, that deposits, the government had to make sure those deposits were good. The money that the Bank of Ghana had lent to them, which was in excess of 3.something billion, and if you take the unsecured portion alone, essentially you offset it with what Unibank had with Bank of Ghana, it was almost 3 billion. That money can still not be recouped and given to CBG. So you add all of that together, that is what I am talking about. So I'm talking about the money that the country has lost. When it comes to what the government tried to retrieve in court, they were focused on things they can prove emphatically within that adversarial process, which is the courtroom. And that is not the only place in which accountability is handled. And that is the difference between my analysis and some of the analysis that I've seen flying around. So essentially, you go into the Unibank books and you try to understand where did the money go. And that is where you begin to notice that a lot of the money eventually went to related parties. Essentially went to companies that are very closely related to Unibank. And then some of it also, due to the way in which those approvals were made, there was a belief that a high degree of liability attached to Unibank's senior executives and shareholders. And therefore, if we went to court and we said for these amounts of money, the court should help us to pull back, we stand a better chance of prevailing the court. That's not the same as trying to trace the money we cannot at this stage put our hands on and pass on to CBG. That's a different conversation. So you say, okay, there is a lot of money missing. Some of that money, we know it went to companies that these same shareholders own. And I will show you a couple of them very soon. And so we can trace that money easily. And then some of them too, we can see that they've signed some documents and things like that. And we can pile all of that and we take it to court and say, look, for these amounts of money, we think these people should pay that money back. And this is a purely litigation strategy, a prosecution strategy. It is not entirely encapsulating all the money that this country has lost because we have to step in and clean up after Unibank. And that's a critical point that I'm trying to make. So the 7 billion that you saw on that page is not necessarily the 7 billion that is being pursued in court. It's money that through Unibank's various infractions and negligence, and maybe misfortunes as well, could not be traced and handed over to CBG. And for which reason this country had to step in and make good. And that really is the logic. So once that logic becomes clear, then the matter of separating that from the issue that everybody else seems to be focusing on, which is how much money did we trace to different companies that were owned by the same shareholders who owned Unibank, and how much of that reconciliation has been done, how much of that has been separated into monies that we've now traced to other companies, and we think we can target them directly. And I'll come to that point very soon. There are over 90 lawsuits that the receiver has filed chasing different companies directly. So in some of those instances, there's no point then in a courtroom to insist that, you are asking the judge to rule that this particular company is guilty of those particular infractions. And that difference, I think, is what's confusing people. But when you look on this sheet, for instance, you will see that there are a number of big companies that are owned by the same shareholders who were the majority shareholders in Unibank. So Numa Logistics, for instance, the associated funds, the other assets category, the money that somehow went to them is almost 1.7 billion. So essentially, we are talking of something like $400 million of Unibank's money going to this other company through various schemes and devices. Holder Holdings, which has many, many properties all over Accra and different parts of the country. It's a lot of integrated properties, Uni-Precision Printing, LHS, Urban Logistics. There were almost 30 companies that the owners of Unibank also owned that have received different kinds of support from Unibank. Some of them are letters of credit, some of them are whatever, some of them are loans, some of them are advances, etc., etc. Now, the analysis moves from how much money has this country lost in attempting to clean up behind Unibank to why I think that there's more money with the owners of Unibank or the former owners of Unibank, and therefore we should aim for more. Part of it is you have to look at the analysis of how some of that money moved to some of these companies. So there are companies like I've mentioned, Holder Holdings, Yawado, Numa Logistics, etc. And in many of these instances, the money was created out of thin air. So when the Attorney General says that the money that was lent to them was basically fictitious entries and we shouldn't repeat them, he's misunderstanding the issue. The fictitious entries were the credits. So essentially, you pretend that there's money there that you are lending to someone, but actually you are using deposits to lend to that person. So it's not backed by full credits. So your liabilities are expanding without a corresponding increase in your assets. That's really what was happening. But it doesn't mean that the money didn't go to these companies. The money did go to these companies. We have all the records from the work that the receivers and before that the official administrator had done that establishes that. There were also monies that, for instance, they had used to buy bank insurance companies in Sierra Leone. They attempted to buy ADB, for instance, and they had moved the money into some other account because they wanted to buy Agricultural Development Bank. It's a whole range of activities where the monies had moved. Now, in some instances, we can't literally trace them. And I'll come to that point because it's very critical. It's not very clear who these entities are that have borrowed the money. It's been very difficult reaching them. We don't find how many of them are actually going concerns, and that made it very challenging. Some of the money too came from international. So Afreximbank, like I've told you, lent money that was supposed to go to LHS and BOST to do oil business, and that money somehow ended up not going to them. So all of that to say that when eventually all these facts came out, and the shareholders themselves were then confronted with the blatant evidence on record, they came up and admitted some liability, and they made proposals to put some money in the bank. Right. I've heard people talk about 2 billion Ghana cedis. That was not the only amount that they offered at that time. Remember that 2 billion Ghana cedis in 2018 was far higher than 2 billion cedis today. And I'll come back to that point again. When they made the offer of 2 billion cedis in 2018, they also offered to put 4.1 billion cedis of assets belonging to Holder, which is their holding company, which owns a lot of companies in Ghana, into the bank in order to patch up the bank. So when you look at what they themselves were willing to offer at that time, it was in excess of 6 billion. And that tells you the hole that was there and what the shareholders felt they could do in order obviously to avoid prosecution and in order to keep some of their other assets, because the receivers were going after everything, right? So that tells you the scope of the liabilities that they were willing to admit at that time. And that was very important. And then when you look at why that proposal was not accepted, it tells you the scope of the problem. Because even that was considered not enough to close all the gaps, which is what you see on the left side of the screen, which were the gaps that will remain. There will still be a capital deficit, even if all those monies came back from the shareholders and went back into the bank. So that's very critical. Right. And the reason why it's important to use dollars in order to get the right sense of the recovery is because 2018, a CD was worth more than a CD today. If I give you a CD in 2018 and you simply just put it in treasury bills, by now you have way more. So if somebody owes us money from 2018 and is paying now without interest, it's an interest-free loan. So if you are doing the analysis properly, the simplest way, there are a lot of methods you can use, DCF methods, like a whole bunch of methods, but the simplest way to discount it and to kind of make the analysis a bit more wieldy is to take the dollar value then and the dollar value of what you are paying now. So when you strike the balance of that 7 billion that is missing in those days and how much in dollars it's worth, and the 2 billion that is being offered today, you get the point that I'm making around the 10% entry, because the dollar values then change and the ratio becomes clear. Remember also that they are not paying all the 2 billion at once. They are paying 800 million cedis in property, which nobody has valued. And then over 18 months,
nobody has valued.
The government is hoping to recover some of the monies that have gone to other parties other than the related parties, which is exactly the same challenge the receiver has been on all along. So the critical issue is, let's summarize again. By the time that the government went into to close,
so you are summarizing to conclude for me.
Yes, give me a few minutes. By that time, the liabilities, the total liabilities of Unibank, as you can see on the screen, was 9.4 billion. That's in excess of $2 billion. That was really what the issue was. And then the question was, how much of the money could you find in treasury bills, etc., in money that was in cash, etc. And then that money was about 2 billion. So if you take that out, you are left with the 7 billion cedis that I'm talking about. And then you look at where the money went, because essentially if you have all these liabilities, there must be corresponding assets. You find that a lot of it went to companies such as Numa, Holder, Integrated, Uniprecision. Some of those companies today, like Uniprecision, the name has been changed. The asset in a way has become encumbered because the same shareholders have taken some loan from some company in some tax haven, and therefore they claim that they don't own it anymore. And even though they have rented the property out to some people, they have moved them. So a lot of the assets have become complicated, but the truth of the matter is that there's money that is in all of these companies. And in my view, given the money that went into them, it is very difficult to argue that the money that we are getting from them, which at this stage, in terms of the actual hardcore cash of about $60 million, is enough when the country has lost over almost $1.5 billion trying to clean up after Unibank. In terms of the debt owed, people have said that, okay, Unibank also, the government owed Unibank. Why don't you offset that? All that was calculated. Unibank itself, when it brought its numbers, was less than $1 billion in those days. That's cedis. And then, subsequently, there was validation at the Ministry of Finance, and that ended up with only about half of that. So that 500 million that the government owed them, when you offset, is when you still get these numbers that I'm talking about. Now, here is our problem with the AG's intervention, the Attorney General's intervention. The receiver that was appointed, he was appointed according to law. The law gives the receiver certain powers in Act 930, which is the Bank's Specialized Deposit Institutions Act. It's the receiver's job to go and get the money back and to maximize the recoveries. It's not anybody's job. The AG was just helping by filing the criminal lawsuit, which should have played a role of piling pressure on the shareholders or the former shareholders of Unibank. It was not the job of the AG to collect the money. It's the job of the receiver to collect the money according to law. On top of that, the same law also gives the receiver the power to disallow transactions that happen before receivership. So, for instance, all these related party things and the rest, that's why the receiver has a separate civil lawsuit ongoing. So for the AG to now enter in an attempt in a way to preempt what the receiver might do, to us is overreaching. is acting clearly in excess of jurisdiction.
Okay.
The other point is also that the receiver has fiduciary responsibility to the Bank of Ghana. It's the Bank of Ghana that appoints the receiver. So if the Bank of Ghana itself has determined, this is a matter that has been well established in the Supreme Court case in 2023, where the current acting CJ himself reinforced the fact that the receiver acts as a fiduciary of the Bank of Ghana. So really, only the Bank of Ghana can terminate the receivership when the receiver has determined that he cannot recover any more money. And we should also remember that there, as I've already mentioned, there are several lawsuits that are ongoing, target direct individuals. And if we continue to make this kind of arrangement, then what are we telling all the other people that are also owing the company receivership?
Okay.
Essentially, if you're going to make a pact to one set of creditors, what about the rest? Okay. Are they all the 90 people that are being pursued? Are they also going to get a deal that says they should bring 50% or 30%? So really, this is a very serious problem.
Right. Thank you, Bright. We've done some 20 minutes already, but thank you for this presentation. That's comprehensive. But I'm interested in one small point before I come to Kwame Akufo. You have been relying on a particular document heavily to talk about the banks concerning bad circumstances in 2017.
No, I've been relying
That's
on
the KPMG report, correct?
No, I've been relying on multiple documents. As you can see.
Yes, but I mean the document that you rely on mostly is the KPMG report.
No. There was a KPMG report in May 2018 when the receivership was initiated. Because by law, within a certain short period of time, you have to issue something. And then in August, within 3 months by law, you are also supposed to issue another report. So there was another August report. Then there's a 2019 report, which is more than a year after another analysis.
Right.
What I just told you, most of those screens come from the report, the reconciliations done as of March 2025. So anybody who suggests to you that some documents that was in the court last year overrides what I'm talking about doesn't know, it hasn't actually done its homework. So 2025 has been reconciliation, and that is the data that I'm relying on.
Okay, because I was going to ask the question if you had paid attention to the caveat, very significant caveat that they issued in that KPMG report. They said that we have not sought to verify information or performed procedures necessary to express an audit opinion on any financial or non-financial information contained in this report. Accordingly, we are unable to determine the extent to which information provided to us are complete and accurate, and the report should be read in that context. And so, on the basis of that, if they do a further review from what they had done originally at 4.97 billion, and then eventually came to 5.7 billion, and then more recently do the reconciliation again and come to 3.3 billion. And they clearly show us the path why you can say without any doubt that the real debt amounts in cash sort of is only 3.3. So I'm having a difficulty appreciating how you arrive at your calculations, which now impugns the work done by KPMG, the receiver, the administrator, and the receiver now.
Okay, so 3 different questions. First question, the disclaimers that they put in those reports are standard disclaimers because they don't want to be sued and held personally liable. So if you give them an engagement and you sign an engagement letter with them, based on that engagement letter, they are telling you that, those we will not be held liable for anybody suing us, so you indemnify us.
Okay.
And it's not in only one document, it's in several documents over a long period of time. So it's not like if they started with that and then the subsequent document, they remove that disclaimer. All the KPMG documents you will see have those disclaimers because they are indemnification that they need for their own protection. So that's number one. Number two, we were not using data from 2018 that has changed. The data that I showed you goes all the way to March 2025, and everybody can go to the receiver's website and look at the latest reconciled information. And they will see that by March 2025, the capital issue that I just described, the capital deficit issue that I just described, are exactly what they are. And I'm happy also to send you the document that I've just used, and you can put that on your website. The third question around, where am I getting my information from? The confusion that people have is that because they went to court, and in the court process tried to retrieve some amount of money, every time they decide that, okay, rather than use this particular criminal proceeding to do that task, we will simply pursue some other individual directly. People confuse that to mean they've revised it to say the money is not lost. No. There are about 90 different lawsuits in which they are pursuing different obligees, people that have obligations and other liabilities to Unibank. And those are separate matters. So if they decide that instead of chasing this particular individual, we're going to chase somebody else, it doesn't mean that the money is not missing. And that is, I think, what we have to clarify for people.
I've a good number of questions for you, but because we have done quite extensively with you so far, and I have other guests in the studio, let me come to the studio. Otherwise, we have to note that the AG insists that he took a pragmatic and holistic approach, and that as far as he can see, 100% recovery was not possible, and a conviction was not guaranteed. And that's how come he brings us the Bait Capital situation, which I understand they will appeal anyway, where he had the opportunity of taking 10 million and he refused. And then eventually we've lost that case. So he gets 0 in that regard. And to think that both the criminal and civil cases have persisted for over 6 years with no immediate resolution in sight, he believed that this is a best approach. When they give us, by their own calculation, what amounted to the 5.7 billion, they clearly show us that out of that amount, the reason you have a reconciliation that now results in 3.3 billion is because a total of 2.4 billion has been excluded from that amount. And the exclusion is as a result of the fact that 2.1 billion is alleged fictitious amount that were only, cooked in the books. They are not, actual cash outflows. And then the 3 million extra is money relating to Unibank's placement with the Securities and Exchange Commission. They regulate that aspect. It has nothing to do with the Bank of Ghana, and they are pursuing that separately. So with just that out of the way, let me ask Kwame Akufo. From Bright's, analysis, he has a total debt amount of 9.4 billion, completely different from the 5.7, which became the amount that was being worked with, and which has gone through the reconciliation up to this point. He says we didn't get, a good bargain.
First and foremost, let me say that Bright has had quite a significant advantage sitting at home and has set out his case. For we lawyers, it's as if he's filed pleadings and we don't have pleadings and we have to speak to him. Because he sat back at home and said that a huge table put his case together and we have to respond. But we'll respond to his case. First and foremost, it's important to understand that we operate within a system of law. That's the most important thing. We don't operate within a system of self-serving, homemade arguments, which is thrown at the other side. That's not the system we operate on. Secondly, what Bright says, or Bright by Simon says, does not have the tag of a presumption of propriety. Under Section 37 of our Evidence Act, documents emanating from official sources in terms of a report have that presumption of legitimacy. We have a situation where the Attorney General of the Republic of Ghana and officials or agencies appointed by the Republic have carried out an official duty. That official duty has a presumption of regularity. Mr. Simon's work does not have that presumption of regularity. So raised against that which is a presumption of regularity, that which has a presumption of regularity should supersede. Because if we are to follow his example, everybody will sit at home and draw his own flow chart. I appreciate the fact that we can have intellectual divergences, but those intellectual divergences should be fixed on the record and should not be self-serving and done just for your benefit. It has to speak to the record.
He's not cooking up the figures.
I'm not saying he's cooking up anything. We are in the Republic. He has put together figures. He says he's not cooked it up. It doesn't matter. The point is that documents emanating from official sources will take precedence over his work. And that's what I'm dealing with. And that is what we are obliged by law to deal with, and not by virtue of what is put together documents that he's speaking from home. That's not how it's done. We have to speak to documents from official source. That out of the way. For me as a lawyer and for other people, because he spoke of the adversarial system, the most important thing in this dispute or this discussion is what has been the effect of the law with respect to the figures. And I go back to the first issue. It's very important to understand that when the official administrator was appointed to administer the bank, it was for a period of 6 months. It was at this stage that the figure of 5.7 billion was thrown about. That figure, irrespective of the diminution or the attempt to demystify the caveat in the report, has now been shown to be inaccurate, which puts Mr. Simmons and the receiver on a collision course. Because while the receiver said 5.7 billion then and has revised his position, Mr. Simmons has escalated it. Which one are we to take? I prefer the receiver's one because he's coming from an official source. Now, when you are appointed a receiver of a bank, you have 6 months under the law to do your work. If the Bank of Ghana thinks that 6 month period should be terminated earlier, under Section 122, there are 4 circumstances by which it should be done. The bank takes the position that the bank cannot be rehabilitated, the bank has to be liquidated, or there are other reasons. In this present situation, it was never done. It was never done. Therefore, the basis of the revocation of the license in itself was fraught with illegitimacy. And that's the thing that, as a society concerned with law and the adversarial process, we have to be concerned about.
You're talking about the same kind of sin that the Attorney General then flagged.
Well, perhaps we're on the same page.
Okay.
That kind of thinking is not one that I heard Mr. Simmons speak about. He never addressed it. He never spoke to it. He jumped it. But those are obstacles in our path, and they must be addressed. The question which arises for consideration is whether or not the revocation of the license was done properly. 6 months or 6 months period was given for the official receiver. It was not adhered to. Section 122 was completely forgotten. And then they moved on and then they pulled the bank's license. There is no evidence. For example, the receiver, upon giving the official administrator, upon giving the authority to administer the bank, set out a report. That report is not the kind of report that the Bank of Ghana could have revoked the license on, because the bank did not revoke the license under Section 16 of the Bank of Ghana, the Specialized Deposit Taking Act. Even under Section 16, the Bank of Ghana was required to give a month's notice to Unibank for them to make representations as to how the bank will have been rehabilitated. This was not done. The question then which comes back to the fore is that in the absence of these conditions precedents, are we not entitled to step back and ask ourselves, how do we move on from here?
So whether or not they gave them the opportunity to proffer an alternative as to how the bank could have been rescued, they still went ahead to do so.
They still went ahead
they
to do so.
They have suggested that they were going to inject 2 billion and subsequently 2 billion, and all of that was rejected.
That is correct. Now, this letter of, if I pull it back here, is a letter of 5th June 2018 in which this offer was made to the receiver. Unfortunately, this was not given serious consideration, and we've come back to square one. Mr. Bright Simmons talks about the fact that the shareholders of the bank had admitted to making recompense of 4.9 billion cedis or much more than that. If you read the letter, they speak of a ballpark estimate. A ballpark estimate. There is nothing indicating a full and complete admission that these were the figures. Remember, the receiver himself was in doubt about the figures. And it is for such reason that subsequently in court, the receiver comes down from 5.7 billion and finally ends at 2.8 billion per his amended writ of summons and statement of claim. Then the receiver drops down to 2 billion. This 2 billion is made up of 800 in assets, and then you have 1.2 billion owed by third parties, as in creditors, debtors of the bank. The bank is in the business of lending money. So this is where we are when we talk of the bank's liabilities and what is to be recovered. And that's what Attorney General has done in Nolle Prosequi. When Mr. Bright Simmons condemns that process, he condemns that process without regard to the official record. And he cannot impugn an official record merely because he sits on the sidelines and chooses to disagree. He says that the Bank of Ghana did not agree because they thought that this will not do. Now, the question which arises here is this. At the time this letter was written, this was before the bank's license was revoked. I do not know where Mr. Simmons get his information that the Bank of Ghana thought that this will not work, because finally we've come back to full circle. In fact, if this had been taken into consideration then, perhaps we wouldn't be here. He says that 2 billion cedis in 2018 was not exactly what it is today. But then he does not say.
He's benchmarking with the dollar.
It's a good argument.
Using the value of the dollar.
It's a respectable argument. I would have been happy if he had carried that argument to also debts owed to the bank by the government of Ghana. Are we going to benchmark that to the dollar too? He's silent on that. And I don't think it's a fair argument to make. He has to look at the argument in a holistic manner, especially from where he's sitting. So Mr. Simmons' position on the exchange rate should be something that should be applicable to everybody. There's a whole lot of talk about shareholders having stolen money. Such miserable arguments being made but propagated in broad circles. Have shareholders stolen money? Because of these plans, equipment, and property issues and the ratio, the bank had taken the position, which had been brought up at board meetings and approved, the minutes are there, that some of these assets should be held in special purpose vehicles. When the receiver, the official administrator, came upon the bank, these things were disclosed to the administrator at that stage. They were not hidden. And that's why in the letter of 5th June 2018, you see in the third paragraph, they talk of immediately assign holders' interest in the assets sitting in the books of the bank. Part of other assets of about 3.7 billion, which were purchased by the bank, but registered in the name of holder to improve the solvency of the bank. This will be done together with the repayment plan for the direct loans to shareholders. So clearly, this idea of fictitious entries, yesterday I read a beautiful note by my learned friend on the other side in which he spoke of fictitious loans, and it is for him that I make this point. These things were not hidden. They were put on the books to enable capital exposure limits, special limits, and had been put there for that purpose. They were never hidden. They were made clear from the beginning of day that these matters should be put into the system to enable the bank get back on its feet. No tangible reason has been given as to why this was not taken into consideration. He spoke of the liabilities of the assets of the bank having been transferred to CBG. The question is, under Section 1232 of the Bank of Ghana Act, the Bank of Ghana had no authority to split the good assets and the liabilities for the receiver and for the taking over bank. All the assets and liabilities under the law are contemplated to be within the bosom of the receiver. That is the law. The law does not say, even though I know this mechanism of structure where you can move assets, good assets and bad liabilities to other places, the law says the assets and liabilities will be taken over by the receiver. In 2018, that was not done. The exchange rate has changed, and today we are being told by Mr. Simmons from a 31st March or 30th March documentation that the assets, the good assets issue moved us to 711 million. What was the value of the good assets in 2018? In 2018, when the issue occurred? These are very important questions that we have to look at.
You had mentioned that it was bizarre to hear suggestions that some people had stolen any money, right?
Did I use the word bizarre?
Okay, that's my word.
Okay.
And that there was nothing like, theft.
Yes.
The charges, criminal charges, included dishonestly appropriating, or isn't it?
That is correct.
What is that? How is that different from stealing?
It is a semblance of. Prosecutors lay out their theory. The Attorney General himself, clearly in the face of the fact that these monies which go into shareholders for the purchase of the properties or for holder to hold the properties, clearly now sees that because the properties were held in trust for the bank, there can be no stealing here. These properties at the end of the day were held for the bank. So that for people to make this argument is based on emotional drawbacks. The properties were held in trust for the bank. And they are on the books. It had been discussed at the board level and it had been approved. And when the official administrator turned up, these matters were disclosed. They were never hidden. At best, they can be called misstatements. And if you go to the company, the Bank of Ghana, the law, Act 930, if you look at Section 94, I'm talking off the top of my head, the governor, the Bank of Ghana, can examine the books of a bank. And when they examine it and there are misstatements or misapplications, what they will do is that there's an administrative sanction, I believe under 98 to 100, between 98 to 100, where they can punish you by way of administrative sanctions or penalties. Thank you. But it has never been the case that this misclassifications becomes the basis for the revocation of a license. And that's why the law is important. If you put mad things in SPVs, does it then become a basis for revocation of a license? No. It does not become, because the primary remedy under the primary punishment under the law is that when that happens, the person suffers administrative sanctions, especially when the assets have not been looted away but are being held in trust for the bank.
Bottom line,
yes,
the state has a good deal in this approach to terminating the case.
I believe so. An Attorney General's duty is not necessarily to obtain a conviction, especially when the dispute centers on commercial malfeasance, because sometimes it's extremely difficult to prove. Mr. Bright once was candid enough to say that the Attorney General has gone to court and thinks that within the adversarial system that we operate, this is what he can achieve. That concession that he makes should stop him from making further statements that we have not had a fair deal. Because when we go to court, we operate within an adversarial system. And that adversarial system requires us to operate by the rules. The rules and the facts now clearly show that these are the matters at hand. Their cooperation of the shareholders or the former directors to give to the government of Ghana to recover the 1.2 billion does not make the 1.2 billion a liability of theirs. So we have to get it very clearly. Unless Mr. Simmons can say somebody is stealing money. But there's no such evidence.
The minority has raised some questions.
Very well.
And the public is concerned.
Yes.
That this is an Attorney General who was lawyer for this same party.
True.
So smacks of conflict of interest, smacks of collusion to get his client off at the expense of the state.
I recall that in constitutional law class we were taught about the doctrine of necessity. If I became a Supreme Court judge tomorrow, is it the case that if something was concerning Nane Akufo-Addo, I could not sit upon it? If, for example, I was Chief Justice, tomorrow I couldn't hear the case? The Attorney General has found himself in an office where he has to deal with people that he acted for in the past. By virtue of the doctrine of necessity, he has to take a decision. I always say that when a person exercises a discretion, the mere fact that you have a disagreement with the person over the discretionary use of that power does not necessarily mean that the person is wrong. The question at stake is on the facts available and on the basis of the reconciliation of 2 billion cedis, has the Attorney General taken a decision which is pragmatic, fair, reasonable, and considerate within the circumstances, or should we continue litigating? You have to look at the cross-examination, for example, of some of the bank's witnesses, where, for example, in terms of the capital adequacy ratio, the method which had been used to calculate it, witnesses were pulling back, claiming they didn't even know who had done it. When the 5.7 billion cedis was put to witnesses, witnesses were stepping back as to how that figure had been arrived. An Attorney General is entitled to take a fair position before you lose the case, because you see, in a criminal prosecution, it's proof beyond reasonable doubt. So at the end of the day, taking into consideration the fact that the revocation of the license was not done properly, and that's a matter that Mr. Simmons, for all his scholarship, does not speak about. Perhaps you do a counterclaim when we are finished speaking, but he doesn't speak about that. And we, for us as lawyers, always say that you can't put something on nothing and expect it to stand. So we have a situation where the revocation itself was improper. We have a situation where the audit figures have kept changing. nobody can make the reasonable argument, can make the stand-up argument that the receiver is now in collusion with the debtors. It will be untidy to say so. So if the receiver today says in court, by way of his amended writ of summons, as had, just give me a minute, let me just check.
Sometime in 2024.
20th of March 2024, says that the debt then was 2.8 billion. And remember, at the time that he cascaded down from 5.7 to 2.8, it was not a settlement issue. It was not a settlement issue because they were now getting to grips with the full picture of the situation. That reduction was significant. But then again, the bank had lost its license on the basis of a figure that has now changed. Who is asking that question? Mr. Simmons doesn't speak to it.
From where you said that is an unfair treatment,
I don't like
by the state against the bank.
I don't like to put this emotional tax on issues. I just like to put the facts forward. I like to say clearly, or I like to submit clearly, that the figure upon which the bank lost its license has now changed, and it changed in court.
So if they are very, strong about that point, they shouldn't be interested in settling. They should rather be interested in pushing this against the government and seeking that in the end, their license is restored and the government pays for the wrong they committed against them.
The point at stake is that people do not, nobody has the eye of the evil prophet to see tomorrow. Sometimes you may think you have a very good case in court, but the judge may see differently. And therefore, sometimes when, as they say, what's this thing saying in Julius Caesar, there's a tide in the face of men, which when taken at the flood leads unto fortune. Omitted all the voyage of life is bound in shallows and miseries. On such a full sea are we now afloat, and we must take the current as it serves or lose our ventures. Perhaps that's how they see it. I cannot get into their minds. But sometimes it's important to take what you have rather than to wait for the end. The question is, or the fundamental point that we can never run away from, is that the license was revoked on a figure which has now changed.
That's the point you have made a number of times now.
Yes, I was emphasizing it, so I come down to it. So now that we've come down to 2 billion cedis, and the apportionment and the components have been made very clear, and Attorney General is settling on it, people have said, for example, why is he entering a Nolle Prosequi? Why is he not going under Section 35? Why is he not going under the Plea Bargaining Act? Our law makes provision for these things when people are pleading guilty. Nobody has ever explored the thinking that when there's a criminal case running and a civil case running, and the government sees that it cannot win, it cannot force somebody into a plea bargain position, and therefore can enter into a consensual settlement. So I like to say to those who make that argument that clearly Section 35 and 70 of the Plea Bargaining Act are not applicable to the facts of this case.
Because you must plead guilty first.
Yes.
Before there will be a plea bargain agreement.
Absolutely.
Okay.
In this case where it's a 50-50 take, and there's an absence of guilt or admitted guilt on the part of the shareholders, there can be no reference to these particular sections that people are propagating.
Okay.
I'll yield back
so it's I'm beginning to appreciate it from this point that it's as if, these individuals are saying, you members of the public suggesting as though we were down, guilty, down, and some favor is being done us. Sorry, no favor is being done us. We don't believe that we would have lost this matter. But Oliver, did you also speak too early when you sought to suggest that the 2.1 billion, which constituted fictitious amounts, and it is not about cash outflows, it's not a matter that you should be letting the people go on what do you feel now about the developments?
I think that there's so many issues that have come up that we need to take our time with. There's a conflation, first of all, about the questions of revocation. There's questions about how much is recoverable, whether in terms of what the receiver estimates. And also there are questions about violations of law. Now, in white-collar crimes of this nature that we're talking about, it is not a simple question of whether or not a person stole goods and how many goods are. There's a reason why the financial institutions and trading, and also in terms of listed companies, we regulate them in a particular way, because they have the ability to procure significant private advantage that we must be careful of. So, for instance, when you take the receiver's estimation of related party transactions that happen, the law says that it cannot be more than 5% of the bank's net owned funds. Now, those fictitious transactions is to obscure the capital position of the bank in order for you to be able to engage in lending to related parties of up to 5.3 billion. That's a serious crime. There's a reason why we regulate and we try to prevent this, because there's so many economies that have been wrecked by these kinds of conduct, and we want to prevent that. So when something like this happens, and you come back and say that, yes, even though we're doing this and we're manipulating and cooking our books, there's no money lost, essentially, because we still owe you money. The reason why we limit the extent of related party transactions is of the difficulties of recovery. So you might say that, well, it's still loan owed by an individual or an entity, and then we can use the civil term that is non-performing loan. But in fact, what you have done is that you have been able to dip into deposited funds and use it for your own private businesses and refuse to pay back.
May I just say a word very quickly? Okay. I did not say that there were loans given to the shareholders or related parties. I said that these properties were held in trust for the bank, and that when the issue came up, they were disclosed, and that if these were misstatements, there's a remedy and a punishment regime for it under the law. That's what I said. I didn't say there were loans.
So about the point you make, the Attorney General is telling you that, look, I'm looking at the money. I'm looking at the expense the state has to go to seek to recover something. And I'm looking into the future. I'm saying if this matter will take us how many years, by the time we're done, I probably may have nothing, to sort of recover, even if I won. So this is the best way. You say this is a crime for having, make this fictitious sort of booking. That's a crime. So you should be prosecuted. He says, I'm more interested in recovering money than prosecution.
No, this is important. The fact that the Attorney General, and I defer to the Attorney General's logic and how he wants to be able to conduct this matter, says that because of my estimation of the difficulty of recovery in certain matters, I'm taking a different approach, does not excuse criminal conduct or criminal liability. It doesn't. It doesn't grant anybody a moral platform to come and now suggest as if they have done nothing wrong in the first place. And it's as if this is where the rebranding of the conversation is going to. That these individuals were completely infallible, did nothing wrong in this contest. And now look, even the Attorney General is now vindicating them. At no point did the Attorney General suggest so. The Attorney General says, I have looked at the difficulty of how we can recover some of the monies made. And when he's talking about recovery of monies is not relating to the crime of cooking the books. He himself admitted that there was a lot of book cooking that happened. So when he's talking about recovery, he's only talking about money that I can be able to get. There's no doubt, even in terms of the receiver's attempts to recover money from Unibank, that there's been so many challenges. The matter was first struck out, they went to arbitration, they are challenging the arbitration. We're just going back and forth on the process of how we're able to recover the money from.
In 6 years, only 2 witnesses.
This is a question that invites us to be able to re-look at our judicial system. It is not a question to now allow other people to suggest that we were always holy in the first place. And that's what I kind of see a rebranding of the conversation.
They say that they admitted from the start, from the outset, that this 2.1 billion is money that, was fictitiously
now, you see,
put in
I have
there.
never
so they haven't said they
I have never held a million CD before. So when I hear things like it is only 3.7 or 2.3 billion, I quiver in my boots to say that we are talking about huge sums of money. When somebody says that, oh, oops, you caught me, I can bring back the money and be free. What are we talking about? These are huge sums of money. So it's a question of also, again, the criminal justice system is not only set up as a state for the recovery of monies alone. And if the driving logic is that whenever people caught themselves in this case, we take how much we can get and go away, we must think about the repercussions of whether or not we are disciplining conduct within the banking system, generally for everybody, for the posterity. So I have no problem if the Attorney General says, even if we are going to lose this money, posterity and the health of our economy for the long term requires that we must take these decisions and go forward with it. Even in the question of the wage capital, whether even though money has been, well, let's say at the status of affairs now, that the Attorney General says we've lost the criminal case, it doesn't stop a civil case from going forward. A civil case is a recovery which is a bit different standard of proof. So it doesn't stop that. Recovery can still pursue. Civil recoveries can still go on.
And this is a point the Attorney General has affirmed. Yes. That is a civil process that it seeks to recover money.
So the civil process must go on. But the criminal implications of individuals within our society that are able to misuse public depositor funds or obscure their use of depositor funds and then invite the state to put in money, so much billions to be able to save them because too big to fail, or you must be able to protect depositors because there might be a run on
on fund managers and other things. Does it not matter, or does it matter that the bank's exposure to the government was partly the reason they were in the circumstances they were? I see these arguments all the time. Government borrows money from every bank. The portion of what the government owes the bank does not impair the bank's capital ratio position. Like, it is not so significant as to be an excuse or a red herring that we use to divert the conversation. Yes, the government owes everybody. The government owes individuals who are waiting for tax refunds. It doesn't mean that when they commit crime, you say that, but you owe me money, that's why I couldn't pay, or I was hungry at a particular time. That's the kind of straw argument that is being set up in this case. So the question is, in the significant time when the decision to revoke the bank, the license was made, was the amount owed by government so significant that if it was paid, it would have saved the bank? No. There's a suggestion, and what you have reference to, Dame's advice. Dame's advice is not saying that the revocation is incorrect and improper in law. Dame says that his view is that Section 114 cannot lead to the appointment of a receiver or the termination of a license. He's referring to the report made under Section 114. He has not said at any point that the Bank of Ghana cannot exercise its powers. Based on the information that was received from the receiver, and say that there's been Section 16 breach, or for which reason I'm going under Section 123 and appoint a receiver, there's nothing that impugns that decision that the bank is capable to make. In fact, the only basis, and it's not true that the only basis under which the Bank of Ghana can revoke a license is when you are not able to refund money or other things. If you have been given a license, you're supposed to respect the body of our laws under the law, and you have shown consistent disregard for those laws, which has led to significant impairment of your capital position. The bank says that, no, this is not a bank that can be run honestly by you individuals, and so I can revoke that license. It's a different matter, and I know that whether they are entitled to pursue it or not is different. But there's an important concession that he made even in his speech, which is that our decision, you quoted a poem, that our decision whether or not to go and pursue those claims is that you must also evaluate other factors. It is the same other factors that the Attorney General is evaluating in this case, because we know how the nature of the judicial system is, and has decided to take a particular position on it. There are three things that I will take as a problem with the Attorney General's position. One, I think that in the matter where people are becoming growing suspicious of your own role in the matter previously, it was not sufficient to issue that statement that they did, which said we have recovered 60% for which reason you have dropped. We should have been brought through a workshop process where we understand reasoning before you issue that kind of statement. So that was a failure in the first place. It is not true, and this suggestion that because you once acted as an Attorney General, you are compelled by necessity to be the one who is involved in that role. We see that same of thinking that we are challenging with respect to empaneling powers of the Chief Justice and other things that we are doing in this state. When the Attorney General in Trump's case decided that Trump was being investigated, he decided that he was going to build a Chinese wall, appoint other competent individual to be able to handle this case and advise the Attorney General properly. There's nothing in our laws that stops the Attorney General from having a special counsel, from having any of the other officers take the lead on this matter because of his own previous dealings, irrespective of your power. The fact that power that exists doesn't mean that remedial actions cannot be taken to be able to insulate yourself from the decision-making process around this, particularly when it is legally possible of legal contention. So that's the second thing. Again, it's not about whether or not he's wrong in his assessment, but the appearance of, Martin Abidi talked about the former lawyer of Dufo was negotiating with himself as Attorney General. These appearances in a public policy matter can create impressions that weaken trust in the office. And it's about protection of trust in the office. Thirdly, when you are making the decision regarding what is recoverable or not, we do not know the extent of conversation that has existed between the Attorney General and the receiver and the implications of the receiver's work. We don't see the receiver speaking. We don't know what extent of what collaborations or discussions have had and whether or not it compromises the civil matter or not. So when Bryce says that the receiver is the only person who is competent in law to recover money, he's technically correct. That he's still in a fiduciary responsibility vis-a-vis the Bank of Ghana, who has expended those amount of money. What conversation was had between these?
Will anything change if I told you that the receiver endorses 100% the position of the Attorney General as put out?
I think that it is important for us to know that the receiver would then communicate this matter to us. I think that it is fair. I am not discounting the possibility of an agreement that's viewing the difficulties I've had even within the courts in trying to recover this money. Because the essence of the criminal prosecution system, Bright says this, is that it also allows pressure to be brought to bear on the individuals for them to be able to
to deal with the receiver in a particular way. Because if it's left with the civil justice system, well, we can be in court for 100 of years.
Does it also matter on the other leg of the suspicion of complicity or some wrongdoing for his own former client? When he discloses to us that a number of people were involved in this negotiation. It was a prolonged negotiation. There were officers from the Attorney General's office, including, is it the DPP, the Director of Public Prosecutions. So it's not as if he single-handedly led the process.
So when the NDC was campaigning to be elected, they said clearly in their manifesto that they were going to conduct a forensic audit of the entire banking sector cleanup. The expectation then is that there's a plan and a roadmap that Ghanaians will be privy to as to how this was going to unfold itself.
Potentially to restore some licenses.
Yes, and potentially to do all of that. Now, we haven't been given the benefit of a holistic review as it stands, and then be able to assess how this decision-making was going to happen. Now, I said that the process of how we reach the decision, that has to be sufficiently workshopped with Ghanaians. That if the Attorney General, who is clearly not media shy, had come out in the beginning and said that with a specific question of Unibank, I am concerned about the delays in trying to recover. I'm concerned in the state's case against them in the criminal process. And so this is the procedure I'm going to put in place. And whatever comes out of it, I am going to abide by because of my own previous dealing with it. Unless I feel that I have an ethical duty to protect the Republic, even in the instances where the committee or the process I've put in place does not go far enough in the protection of the Republic. If we are being brought along in this process, I do not think that anybody who then sees that the Attorney General has said that this is what we have done, and this is why, on the basis of that, we have taken the decision, will be so aggrieved. It is the absence of information, particularly in a state where people have grown accustomed to elites getting away with crime, that people then feel sort of heart-changed. And it's a damage to his own credibility and reputation that he did not think as a politician in this process. And what do I mean by this? A politician carries the people along. So it is not just a technical question of what lawyers do in the close confines, but also how you bring the public along to buy in the end result. So we don't take that for granted. I think that they took that for granted in just trusting his personality and what he says at the end of the process.
From where the receiver sits, and I'll bring in Vicky Bright now, from where the receiver sits, in fact, when you say the recovery is 60%, from what I've become aware of how the receiver thinks, it's actually potentially beyond 60% recovery. So the criminal case involved transactions amounting to 1.2 billion, out of which the accused persons have committed landed properties valued at 824 million towards the settlement of their debts. They think that that would amount to a recovery of over 60%. In fact, that would be 69% in that case. In the civil case, the amount totaled 5.7 billion, including the amount in the criminal case, which has now been revised to 3.3 billion on account of the fictitious loans recorded on the bank's books, which do not involve cash outflows. Based on this, the people involved, the accused persons, again propose to settle through what they say is a structured, approach. The sum of 2 billion. They can see this clearly as yielding a recovery of over 60%. Once again, this will be precisely about 61%. What do you say?
I think I want to just make some general comments, because I guess if I were to sum my view on this, and we've all listened extensively to a lot of analysis on this, I would say that I'm not happy with the decision, but I can understand why the Attorney General made that decision. We under Nolle Prosequi, we know that he's not obliged to explain himself. But for the purposes of transparency, he chose to do so. And I am glad he chose to do so, because if he hadn't done that, some of us would have sat there scratching our heads and wondering, what's going on? Is this the new normal? Are you opening the floodgates to allow people to steal and just steal enough so they can have the pots to negotiate their way, and keep the rest of it? And I would also have been wondering how this sits with the oral, process, the oral anti-corruption processes that are going on now. So for me, it was good that he did that. Maybe now we find ourselves scratching our heads about something else, the figures, which you were talking about. I want to say that the way some of this has been packaged seems to suggest that it's bad, but it's not so bad. These are real crimes. Let's not be confused about that. And these are very serious crimes. So I would not want the gravity of the offenses to be understated. I think it's important that we get that, because the Bank of Ghana is there as a regulator for a reason. And not everyone is allowed to hold a universal banking license. You have to go through very rigorous compliance procedures to be awarded or given
the Attorney General says he would also love to have convictions, but he says he's being pragmatic.
Yes.
And he's taking a holistic approach, because 100% recovery was not possible and a conviction was not guaranteed. Is this a statement of fact to you? Is this a statement of fact, reality?
I think in reality, look, when you go through all these cases internationally, it's 100% is never possible, is it? So everyone tries to get as close to it.
Conviction is not guaranteed, is he right?
And conviction is never guaranteed either. I mean, these are just mere facts of life. Sometimes you go to court and you expect to get a conviction and you don't. Other times you expect to be free and you are convicted. So just as a general rule, that is a fair statement. Whether or not that applies in this particular context is another matter. This whole non-conviction-based asset recovery scheme or regime that we now find ourselves in is also interesting here. I know that in some countries, like the LATAM countries, for example, they have them for even drug trafficking and corruption charges. In Colombia and Peru, they have actually enshrined this in their legal system. And then when you come closer home to Africa, Angola, Cape Verde, Mozambique, and then, the UK, whose laws we follow very closely, they also have it in both their civil and criminal proceedings. So for asset recovery orders and forfeiture orders. So I think that...
but that nomenclature, it might be problematic. And last week, when we're discussing the same issue, people have said, non-conviction-based asset recovery. This is not what that is. We presently don't have that sort of, legislation
enshrined
for
in
it.
Yes.
But non-conviction-based forfeitures are supervised by the courts. That's what they are. It's not you, the person involved or the accused person sitting with the Attorney General, prosecutor, and agreeing, and the Attorney General going to enter a Nolle Prosequi.
That is correct.
Because this is beyond the reach of the court.
Yes.
Once you file a Nolle Prosequi, the court can't say anything.
Then the Attorney General is a law
unto himself. So we shouldn't be calling it anything like non-conviction.
It's similar to it. It's not exactly the same thing, but as you said, this one is not. It's just a regime. It's a power that the Attorney General has and can exercise. And I'm thinking that he has this kind of regime at the back of his mind when doing these things.
Again is applicable. That again is applicable because we need to educate our audience too.
Yes.
It's applicable to where the law enforcement ascertains and makes the conclusion that you have what your income cannot explain.
Yes. Yes.
This is a completely different thing.
Yes.
like in the Constitution, Article 2864.
2864.
That
yes.
if after your declaration of your asset, if we find that you have something which is not attributable to your income, attributable to inheritance, a loan, or reasonable earnings, then that will be forfeited because it is you can't explain it.
Yes. So, well, anyway, this is the route that he's chosen to go, and you know, we are where we are with it. So, what I'm trying to say is that the context which he provided was helpful, because without that, I think there would be serious questions that would have been asked.
Okay.
My question, which I'm asking myself, is that where is the punishment in all of this? Because there has to be a punitive element. Do we, for example, are we saying that these are people, or should we say, or probably we should say, that they should never be allowed to run a bank again or any financial institution again? They should not be allowed to even be directors of companies again, because you have managed things so badly.
Those are the rules, actually. So that is the situation. If your bank's license is revoked or your financial institution's license is revoked, this is the consequence you suffer.
Yes. Yeah. So we just have to make sure that, because they have a lot of related companies. They have a lot of related companies, and we are being told in Bright's expose, he said that some of these related companies have been resurrected or disguised under other names.
Almost 30 of them.
Almost 30 of them. So when I say what I say, I'm stretching into those related companies. Because yes, under Act 930, it's clear that what the consequences are. But we have to look beyond the face of it and look into some of these related companies. These related transactions that they've been involved in and all that. I mean, there's a lot of deception here. You know, a lot of deception and just hoodwinking the regulator. You know, and I'm not saying the regulator is innocent, because they should also have been able, their audits should have actually disclosed some of these matters. So I guess that's another argument for another day. What we all take heart in is the fact that with the Nolle Prosequi, the door is still open for punishment, should they come across any new information or evidence that will warrant the case to be reopened. So I guess it's been packed rather than the doors shut firmly. Because if he had done a withdrawal, that would have killed the case.
A withdrawal after prosecution had closed their case. Then that would have actually shut the thing down. But he chose to go down that route. So the fact that we can, you know, I guess the door is ajar, it's not completely shut. So let's see what happens next. So, Abraham, Dr. Nyaho Tamaklo sends in this message. He says the recent Unibank case where the Attorney General utilized the Nolle Prosequi to discharge Dr. Dufour and others served as a stark reminder for our political class to tread carefully in handling sensitive matters. The application of such legal instruments, while within the bounds of law, can be perceived in various ways by the public. It's crucial for leaders to consider the implications of their actions on the populace. Given the general public's limited understanding of the legal intricacies, it's imperative that electoral promises are honored to avoid perceptions of being taken for granted. The trust between the governed and those who govern is fragile and must be nurtured. When promises are made during elections, there is an expectation that they will be fulfilled. Failure to do so can erode this trust and have far-reaching consequences. This is what Nyaho Tamaklo is saying you are bringing upon yourself, that the goodwill that you have as a government is eroding. You are losing it.
Samson, I don't think this falls squarely under what Nyaho Tamaklo is talking about, even though he's talking about it. You see? There's a saying in our language, that's you and me's language, that if grains pour in the soil you cannot collect all of it.
Correct.
That's a fact. Now, you have an Attorney General who has inherited a case which has been running for 7 years. He will definitely review the case. And don't forget that anytime you put together lawyers from the Attorney General's department to prosecute a matter, it is an expense to the state. He then reviews the law, the case, and this reviewing of the case will not be done only by him. So he comes to a conclusion that, look, in this particular matter, I cannot guarantee conviction. In this particular matter, why don't I cut my losses? And takes a decision of this nature. He looks at it and says that the state will benefit if I engage in what we are calling non-conviction-based assets recovery. As a nation and as a people, are we interested in recovering what has been lost? Or we are interested in seeing the full haul of the case, and then at the end of the day, if they are acquitted and discharged, we say that Attorney General has done well. Which do we want as a people? In this particular matter, I've heard that Dr. Ayene acted for Dr. Dufour. Kwame Akufo has rightly indicated the doctrine of necessity, but let me also place on record that he only appeared once. It is not as if he conducted the case. At the trial, he wasn't part of the case. The case was actually taken over from him to Safo Boabing, I think so.
That's correct.
Yes. And so, those who are talking about the fact that Attorney General is using his position to, as it were, free NDC connected people, I ask the question, why is the prosecution also only about the NDC connected people? Why is the prosecution also just about NDC connected people? So, I am of the view that once the Attorney General has taken this decision, we need to subject that decision to scrutiny. Is it actually true that 60% had been recovered? We need evidence to show. That, for me, should be the argument. That, for me, should be whether it is true that the state will benefit from this 60%. The next thing is to say that...
Before you go to the next thing, you just a while ago endorsed the doctrine of necessity as espoused by Kwame Akufo, right?
Yeah.
Not too long ago, the Chief Justice was embattled, and there were cases that were going in the courts concerning her, and she was still empaneling the judges. You were very unhappy about that when the NPP kept saying that because of the doctrine of necessity, once she still remained the Chief Justice and she had not been suspended like she now is, it was her duty. She and only she could empanel the court.
But don't say Dominic, Samson. People will make suggestions. People will make comments. The position is that she did it and she was in the right to do it. But you can't stop people from making comments.
No, I'm saying,
yes,
you were unhappy about that situation. You criticized that situation, that it ought not be. So why in this circumstance you say, as for Dominic Ayene, the doctrine of necessity must apply to him?
Samson, I've indicated to you that whatever decision you take, once it's supported by law, doesn't mean that people will not still feel uncomfortable about. But at the end of the day, her position prevailed. And so this is also one of the situations where the doctrine will apply, and it will apply in favor of the Attorney General. The other thing has to do with the fact that if the Unibank matter, which is before the court now, which is before the Attorney General now, and he has, as it were, provided this way forward, are we also going to be interested in whether or not the state has violated the rights of Unibank when procedures that were supposed to be followed for the liquidation were not followed?
The revocation.
Revocation, rather, were not followed? Are we going to be interested in that? And I also disagree with my good friend when you spoke about the fact that what government owed Unibank was infinitesimal. It doesn't matter. Would that have also helped Unibank to shore up its books? Would that have shored the Unibank books, which would not lead to the revocation of their license?
The receiver, that's the Bank of Ghana, appointed at the time to be in administration of Unibank, had called on the Bank of Ghana and say, you owe the bank, pay the bank. Right? It didn't matter that it was the Bank of Ghana that appointed it, the receiver or the official administration to be in it. He still said, you owe us, pay us our money. Because maybe you can help us to stay afloat.
Because there were a lot of contractors who had gone to that bank and secured loans to do government work. Government failed to pay the contractors. The contractors couldn't also pay Unibank. Was Unibank also, exposed by that arrangement from the state? And I think that the current situation where the Attorney General has come out with this type of situation is best for the Republic. And like Vicky Bright indicated, the Nolle does not, as it were, and I heard the Attorney General make that point during his press conference, that if they stumble on new information, they can still pursue them because the Nolle does not end it all.
Do you believe that?
Why don't I believe? What, do you have anything was anything written on his face that you don't believe? Something?
You mean an Attorney General in a different regime?
No. What's wrong?
This regime.
Why? This same Attorney General was then an Attorney General and prosecuted an NDC person. You know that. This same Attorney General, Dominic Ayene, prosecuted my own brother.
Interesting. So those of you who are a bit worried that it doesn't look like we have sufficient time, let me let you know that we have an extended time, and that's why we are taking time to make sure that we discuss this matter thoroughly. Comrade Boateng, what do you say? The minority held a press conference led by Kwame Ayimedu-Antwi, and they raised the issues of the optics that didn't look good because of the Attorney General's previous, position as a lawyer for Dr. Dufo, Unibank, and so. When you hear that whether or not he was a lawyer for him does not change the figures that we are speaking to. So what's wrong would have been occasion?
Yes, it may not change the figures, but obviously it will influence one decision or the other, because we all know that the decision to prosecute or not is one that is reposed in the AG. So if he had previously acted for a party, and not the usual clients lawyers would have, but one that is also a member of his own party, a leading member of his own party, nobody can rule out that affinity that can breed some influence.
Do you think sincerely that there would have been an Attorney General or deputy within the NPP's regime who would not come into contact with their clients after they had become Attorney General? Because the Attorneys General are experienced lawyers. They would have had many years of practice. They would have done maybe 15, in the least. I don't know an attorney general who's done less than 10 years in practice. So they will have clients, and they may come in contact with them when they are executing their job as attorney general.
Yes, in fact, I agree with you. And, you know, sitting down here listening to the arguments, exactly what I was thinking was for us to begin to look at that area as a nation. Because, I mean, obviously, as you did indicate, as a lawyer, you obviously, you know, have clients. So if you come into any statutory positions, one of those clients may, you know, have a case that you would have something to do with in your official capacity. But I will also defer to the argument made by my brother that in instances like that, it is very important that we create some insulation, some buffer between the AG and then those who will have the hands-on duty in respect of that matter.
The ultimate decision will be that of the AG.
Yes, and that is also problematic because the AG mentioned the DPP and other people that were involved, but these are also people that, you know, work under the Attorney General. So the influence line is not truncated.
They're professionals.
You know? Yes, I agree. But then it is also a perception. You know, and the perception is very important, very, very important, especially in this enterprise, you know, of governance. And that takes me even into the public trust in the whole criminal administration system. What we know and what we know to be the jurisprudence of our criminal justice system is that inherent in it is deterrence. And that is number one element that, you know, runs through our criminal justice system. If you take that out and then we begin to wade into other issues with economic motives, then we are losing what primarily our criminal justice system is supposed to do. The public expectation is that if you do wrong to the state in a manner that has been done, you should be punished. When we are talking about punishment, we are not only talking about custodial sentences, but at the end of the day, there should be a certain pronouncement, you know, judicial or otherwise. There should be a certain pronouncement on guilt, which will go with you with all its attendant consequences. But if we begin now to be saying that, you know, once we can get something, once we can begin to negotiate and be able to recoup, you know, what we have lost, then we can replace, you know, what is the criminal justice system is supposed to do. We can replace it with a civil arrangement. It becomes difficult, and this is very, very fundamental. Very, very, very fundamental. I think that it will begin to create problems for us. The public will begin to think that, and especially will not be good for the political class, because what will happen is that you have people who are too big to be jailed. You know, for offenses that people have gone to jail for even lesser, you know, offense. It doesn't look too good for the political class, and then the whole integrity of our criminal justice system. Again, I have problem with the position of the AG in respect of the difficulties that he professes, you know, with continuing prosecution. Reading his presser, I don't...
6 years,
yes.
2 witnesses so far.
Yes, we have had cases that have traveled decades. Even some that has to do with, you know, mainstream crime, murder. You know, when it is assizes period, you have cases that have traveled over. But those do not become the reason for abandoning prosecution. I'm one person that would not want to see, you know, anybody in prison, and obviously not a senior citizen like, you know, Dr. Dufo. And that is why I rightly indicated that we are not all talking about imprisonment, but a certain judicial pronouncement, which will give a certain, trust on the part of the people in respect of the system that we are all running. The AG does not even pay filing fees. So I do not see the whole argument of cost. Is it?
I say you don't know cost incurred by prosecutors when they go to
no, if you are talking about, are you talking about salary of
talking about time and everything?
Yes, but we do so for all other cases. We do so for all other cases. If you go to the registry of the court, there are so many assault cases, there are so many murder cases, so many other cases being prosecuted by, officers of the Attorney General's office. Why is it that in respect of this one we are talking about cost? And cost in respect of what? More so when you do not pay, filing fees when the state attorneys file their documents in court. I don't see it. And I clearly do not also see the difficulty. If you say that conviction is not guaranteed, in which matter can you 100% guarantee conviction? Not even in murder. So when we go to court, our duty is to put our evidence before the court and for the court to look at it, evaluate it, and come to a certain conclusion. There's no single matter that you think once you institute it, the outcome is
There are some matters you have ocular proof. So it's not too difficult to say this matter.
It is still subject to the judges. You'll be surprised.
The OSP and the video of the bribe. Even in ocular proof, we are not able to
sometimes, yes, and sometimes the frustration on the part of lawyers.
That was an interesting situation, right? The problem with that case was that while he gave the money, and you can see that money exchanged hands, he doesn't say specifically that I'm giving you so you vote for me. But they show the video where he's demanding a refund of the money because he did not vote for him. And yet the judge says there's no proof that this was the purpose of the money.
That's the problem sometimes. That's why I quoted the poem. But there's this stringent attitude by my friend here, my learned friend here, to speak about conviction. And I have to say, if you look at the Epstein example in America, when Trump was in opposition, he kept on belaboring the point. Today he's come back to haunt him. When we speak as lawyers, we have to use the threshold of objectivity to ensure that when tomorrow we are back in office or we have official powers, we are not caught by our own languages, like my friend here started struggling with the doctrine of necessity.
So let me take very quick comment from Bright to conclude. So we move on to the next subject. Yes, Bright. Hello, Bright Simmons.
Thompson, can you hear me?
I can hear you clearly.
Oh, very good. So I need to make a few reactions to what
the manner, for example, the manner at which you arrived at the 10.6% is flagged as clearly unfair.
Well, there are a couple of points that I think we have to make. So one of them is that my very erudite colleague on the panel, Kwame Akufu, clearly evidences why Unibank retains him. So he's done good advocacy for them, as I'm sure he's done in court.
What is Bright saying?
That's good.
And Bright has had the advantage of sitting at home and preparing his notes. You have notes all over the place. We have to speak extempore. I don't even know why he's getting the right to rebut. You sit back, you watch us, you file pleadings against us.
You directly address all the points I raised. So first of all, I think it's important that the audience know you are a lawyer for Unibank and has been for a while, so they understand the full context. The second thing I think is that you mentioned the SPV loans, and you try to suggest that all the related party transactions are SPV loans, and that is not correct. The SPV loans is what I've displayed on the screen. If Samson, your viewers can see, and it's very clear that can they see?
Yes, it's on. Except we want you to be very quick about this.
Basically, what happened is that monies that were given to the shareholders by Unibank, some of them were then packaged into entities that the shareholders still controlled, but they classified them as SPVs, and the amount involved was just 650 million cedis. So in terms of the total, this was still around 15%, right? So even if you assume that the SPVs are innocent in some way, it doesn't cover the huge amount of money, nearly $1 billion, that was given to the shareholders to invest in various other transactions in companies that are still active and which is still making money for them. So essentially, the issue is really simple. It's a very simple issue. When Unibank collapsed, how much did Ghana spend to try and fix the problems that were created, including nearly $1 billion in deposits that people had gone and given to Unibank, for some reason we couldn't find money to make good on those deposits, and the government had to step in and put in that money.
But they're arguing that that's your own problem as a government. As far as they are concerned, they were going to inject 2 billion, is it 4 billion in total? Okay, the bank would have survived.
Samson, it's very important that the numbers, we don't get confused with the numbers. There's a certain amount of deposits people have gone and put in a bank. That's number one. There's a certain amount of money the Bank of Ghana has given to a bank, which is our money, the people's money has gone to a bank. That's a number two. The bank has borrowed money from other banks in Ghana, etc. So that's number three. When you add all that up, how much do you get? And that is where you get the 9.4 billion. That's number one. Number two is that, and then when the time came and we had problems with the bank, and we said we're going to revoke the license, remember that under the law, if the Bank of Ghana concludes that the bank is insolvent, the law says it shall, it doesn't say it may, it shall revoke the license within 60 days. So once the Bank of Ghana established that the bank was insolvent, the Bank of Ghana had no further discretion in the matter. The bank had to be resolved. Now, in the process of resolving the bank, we now say, okay, this 9.4 billion that we know you owe people, what are the assets that will cover it? We couldn't find those assets in enough quantity, which is why the people of Ghana stepped in. And what I'm trying to explain to you throughout is that in the end, we spent about 7 billion trying to cover the hole that was left by Unibank. That is the big issue. Most of these other discussions we've had, while important, does not in any way diminish that critical point. That in the end, you and I, everybody had to pitch in our taxes to cover the hole that Unibank left. Whether that was due to negligence, theft, misappropriation, etc., we can debate ad nauseum. Last, which has also been, I think, not sufficiently covered, is that when I showed you a slide that showed how much money went into the big companies that Unibank owned separately. I don't think we paid attention. These are companies that are not SPVs. These are companies that are still operating, and they are still controlled by the shareholders of Unibank.
What he said.
Numa, Integrated Properties, Uniprecision, Alban, Eurostar, Bellstar, etc. Now, those companies, when you look at the monies that was given to them from Unibank, Numa Logistics alone, nearly 1.7 billion. That's roughly $400 million of loans taken from the bank and given to another company controlled by the shareholders. Now, these companies are operating, they are making profit, and I'm sure the shareholders are benefiting. My argument is there is more that we can squeeze out than the $60 million in properties that have not been valued.
Right.
And the 2 billion we should collect from other people other than Unibank. Essentially, as a country.
So Bright, I did pay attention. That's where I suggested that it appears that you have done a better job than all those who have produced these reports.
No, not really. Because the reports, everything I said on this show came from not one report, but several reports by the receiver. That's the point I've been trying to make. So when Kwame Akufu insists that I've sat there and calculated my own figures.
No, I'm not insisted. When you make the statement, for example, the properties have not been valued, it's incorrect. The properties have been valued and taken into consideration for purposes of the reconciliation. It's incorrect for you to make that assertion.
And those documents that the receiver...
You agree, Bright. You agree, Bright, when you say those properties that they have, tendered for valued at 800 plus million, you said no one has valued them. That was an unfair statement.
I'm saying that they are yet to be valued.
How do you know that? Because they are valued, and that's why they put a figure to it.
No, the Attorney General says it depends on how they realize it.
Well, there we go. Now he changes his shifting sands now. Depends on how they did what.
I'm saying that the Attorney General himself announced that those properties, depending on how much they are valued at, if there's a shortfall, that will have to be covered.
Okay.
So that tells you that we already have a risk.
Thank you. Thank you, Bright.
Every document I've used on this show
they were valued by
come from the receiver.
They were valued by three entities, including
thank you, gentlemen. Thank you very much, Bright.
Let me clarify that last point. Every document I've referred to on this show, every single one has come from the receiver, and they are as official as the documents that Kwame Akufo has used. So they know that there's a presumption of regularity that benefits his position but does not benefit mine. It's not correct.
Okay. Thank you very much. We'll have to find out how the receiver is unable to come to the same conclusion as yours, and the huge gap as far as the debt obligation, calculations by yourself and the receiver is concerned. Yakubu Ibn Chambers says that as peculiar as the purpose of a sensitive institution like the bank is, I find it preposterous that a bank like Unibank could muster the temerity to engage fictitious figure entries meant for consumption. It will only be an exercise in futility because the Attorney General is politically aligned with the individuals in the Unibank case. The Attorney General should do Ghanaians the favor by distancing himself from the recovery process. D says that, can you ask Kwame Akufo, has the figure changed into a new figure that would have saved them from losing the license, or the figure changed into a new figure that's more of the same predicament that would still have saved their license? Okay, questions there. George says, conflict of interest. Official duty ought to be done by the one authorized to do so. Even if his deputy were to take that decision in Dufour's case, it would still have been done in the name of the Attorney General. The Attorney General found himself in a difficult situation, but then he ought to perform his official function. Right. Many of your comments, we need to take a break and return to, disguised SML at the airport, where broadcaster Paul Adumochire is being investigated among a number of people for something that must have gone wrong, criminally wrong, and for which he was arrested, detained, and eventually granted bail yesterday. Ayene's apparent conflict of interest also stems from a pattern. Was Stephen Opuni not also his client? Did he not file a Nolle Prosequi in that case? That's a question from Kojo. And Musa says that, Abattoir says that Attorney General's decision to discontinue Dufour and 7 others' case for me is a prudent decision. The so-called banking sector cleanup was nothing more than an avenue for two things: siphoning the public purse and persecuting political opponents. If not, why did the government target only banks affiliated with the opposition? And why spend 25 billion? It's actually 30 plus billion, 31 plus or so billion to collapse these banks when just 9 billion Ghana cedis could have kept them in business. Simply doesn't make sense. All right, we take a quick break. We'll be right back to visit the OSP to look at what it is doing wrong. Paul Adumochire has put up a video thanking a number of people, and people are getting incensed at that particular video. He's mentioning prominent figures in this country who called him, and he suggests that they seem to say, sympathize with him, and seem to suggest that what he has said, he was being witch hunted, could be the case. We'll be right back.
Still, Misaka, and Namum was a summer brabo, and it can afford Swabrabo.
Misaka pensions, Caro.
Misaka or the Sika. Misaka insurance. Momo Fogosuri Echumaden, the Aboye Nina Yesika Hubai, Se MTN, Ana Momo Jumayeni Befrewa, or the 0244 300,000 Befrew. Nenumpo Orin Bitsao, one-time password, and now say Upin code. Ain't one so Yawa Femuji, Nama Weni Naho, Naunsa, and Kaumo.
So, Charlie, the deal there, I almost get her.
Syntax pipe, as tough as it can get.
You get so something with your back, sorry. Oh, what you was a thing. What the cat never won. You can catch it. Hey! Now I'm pipe.
Between and Kafai and Cabo.
Hey, madam, pipe menu.
A Syntax pipe. Metono, Omukacham send a one day pa. Say a fee, say a foam. The other pipe we be a yannick gum.
Syntax pipe.
Why only key?
Come, madam. From today, Syntax pipe in my pipe. No 2 ways.
When you know, pipe ben abe use.
SINTEX pipe.
Syntax pipe.
No hala.
Let's talk hemorrhoids. Hemorrhoids are normal structures located in the anus of all mammals.
But it is only man who suffers hemorrhoidal disease because of the erect closer we have assumed and the squatting that we do to empty our bowel. Hemorrhoids consist of a special type of blood vessels which fill with blood when we are moving our bowel and help to cushion the anus against the force of transmitting the stool. Afterwards, they empty their blood, collapse, help seal the anus to maintain continence. Over time, these vessels lose the elasticity of their walls, become dilated, permanently filled with blood, leading to congestion of the hemorrhoids. The symptoms of hemorrhoids are bleeding and prolapse of the hemorrhoids when passing stool, itching and feeling of warmth in the anus and anal discharge. Laser, ligature, and longo are the modern, minimally invasive, most effective, and painless methods of treating hemorrhoids today.
Winterba Hospital, first Ghana Colorectal Center, in to serve a peculiar health need.
Having gone to Translight Solar, really, it's been one wonderful experience. Since the system was installed in my house, my daytime could be somewhere around 20 cedis. And so I've seen a marked reduction in my bills. And because of that, I am not paying as much as I used to do when I was relying solely on the national grid. My house has now become the city on the hill. With this current doomsaw, anytime my area is off, my house is well lit. Everything is on point. And I can get as much as 13 to 14 hours with my ACs and everything working perfectly well. So I can say, as for Translight, they are the truth, the way, and the light. You have to speak to Translight today. In fact, speak to them now, right now.
Translight Solar. Translight Solar.
Have you been to Aqua Safari lately? Let me share my experience with you at the new Aqua Safari Resort. When you arrive, you're greeted by warm smiles and introduced to your 24-hour butler who already has your itinerary sorted. Enjoy water sports activities like jet ski rides, kayaking, water sliding, flyboarding, and castanet fishing. You can even have your lunch here on the boat cruise. Experience horseback riding, tennis, and some golfing amongst a host of other activities. Let the tour guides take you through the sceneries of the Volta River, the mangrove forest, the friendliness of the animals, local and exotic birds, while you pet and feed them. You can have this large space for your conferences, corporate retreats, and so many activities as part of the package. We chose to have our breakfast with a beautiful sunrise right in front of our cabin. We had an amazing experience and I can't wait to return for more.
Visit Aqua Safari Eco Resort in Ghana, bringing you closer to nature.
Ghana, get ready! The biggest sales event of the year is back. National Sales Leaders Conference 2025, organized by Core Event Solutions, Powered by MGA Consulting and proudly supported by Chartered Institute of Marketing Ghana and Association of Ghana Industries. Happening on August 19th to 21st at the Accra International Conference Center. The special guest of honor for this big event is the Chief of Staff, Honorable Julius Deborah. Join over 2,000 participants including CEOs, Managing Directors, Sales and Marketing Heads, among others, for 3 unforgettable days of insights and high-level networking with 68 seasoned speakers tackling 25 impactful topics across various industries. This is the one event you can't afford to miss. Reserve your seats now. Visit www.nslcaccra.org or call 0502-711-070 to secure your ticket. NSLC 2025, redefining sales excellence for a dynamic market.
Yeah, Bongo. Hey, again.
Hello, thank you for calling MTN.
Yeah, this is Jerry, Jolly J for short.
Hi Jerry, how may I help?
These days I'm not happy with you guys at all. What you guys do is not cool, crowd.
How do you mean, sir?
You've been giving Bongo gifts all the time.
Who is Bongo?
Oh, Bongo, my friend. He purchased in my room. You don't know Bongo.
Oh.
You've been giving free gifts, but I don't. That don't be gift is him.
That's MTN rewards, sir. You can also get freebies because on MTN, doing always gets rewarded. Doing more of the things you love. Talk, text, browse, and more, and you get to redeem free call time or data by simply dialing *550#.
Oh, sir.
Yes, and on Fridays, you can even get extra special rewards like food vouchers, shopping discounts, and much more.
Didn't tell me anything, no. He will move out. Doing gets rewarded, eh? Hey, but your voice is really nice, so. Would you like to know how I got the name Jolly J?
That won't be necessary, Mr. Jolly. Calling customer care service doesn't give you points.
I'm gonna call my mom. I'll call my grandmom. I'll call my ex. That girl can talk, Papa. Hello, Mama. So what's the topic for today?
MTN.
For decades, we have helped businesses connect with their trade partners all over the globe. From Ghana to Burkina Faso, Côte d'Ivoire, Benin, Togo, Senegal, China, Morocco, France, Netherlands, and many other countries. We have made it possible to bring Ghana to the world. We have brought small and medium businesses closer to their customers across the regions in Ghana with our SME support facilities. We have brought relief and smiles to the faces of families with our employee personal loans. With our cutting-edge technology and digital support, we take the burden of complex thinking off you, making life simple. That is who we are, as close as a partner. Bank of Africa. We are indeed the African bank with the global reach.
So, Charlie, the deal there, I almost get her.
Syntax pipe, as tough as it can get.
You get so sorry with your back, sorry. Oh, what am I doing? You was a thing.
What the cat never won.
Hey! Na ampai.
Between the Capai and Cabo.
Hey, madam, pipe, man.
A Syntax pipe. Metono, Omukacham send a word them pa. Say a fee, say a foam. The other pipe we be a yen gum.
Syntax pipe.
Why a leaky?
Come, madam. From today, Syntax pipe in my pipe. No 2 ways.
We need a pipe banner be use.
SINTEX pipe.
Syntax pipe.
In the carry water. No hala.
Number 1 from here, 2 and 3 from here, 5 and 6 from here, for now. Now, I have the number 7, 8, and the number 9.
You need number 10.
Please, I can't eat anymore.
I mean, number 10, liver salt.
The effective liver salt for the relief of stomach upset, heartburn, hyperacidity, and indigestion.
Would you like to try number 11?
What?
Number 10 liver salt. Refreshing relief fast. Manufactured and distributed by Ernest Chemists Limited. This advert is FDA approved.
We face real challenges every day in Ghana, from high rent prices, housing challenges, expensive food, traffic that drains our pocket and reduces our life expectancy, and rising electricity bills. But what if we told you that these problems are all interconnected and there are sustainable solutions that can actually save you money and improve your life? This August, the Joy Sustainability Month focuses on solutions to some of our key sustainability issues. For 4 weeks, we're diving deep into the issues that matter to your daily life. We will explore how you can still afford to own a home in Ghana, why your food costs so much, and what we can do about it, how to cut your transport costs, and practical ways to power your home, amongst others. Every weekday, join our expert conversations on the Super Morning Show and other programs. This is not just talk, it's about real solutions for real Ghanaians, because sustainability isn't just about the environment. It's about sustaining your wallet, your family's future, and Ghana's prosperity. The Joy Sustainability Month, starting 4th August 2025. Your sustainability future starts with the right conversations. The Joy Sustainability Month is brought to you by Joy Business and supported by Fidelity Bank. Believe with us.
Welcome back. This is Newsfile, the most authoritative news analysis platform. And here on Newsfile, as always, we put Ghana first. And I guess right here in the studio, Victoria Bright, international corporate lawyer and entrepreneur. Kwame Boafua Kofu has left us. Bright Simmons has also left us. Abraham Amalba is Director General of the National Road Safety Authority and is member of the NDC's legal and communication team. Kwabena Boateng is MP, Ejuso, and Deputy Ranking Security and Intelligence Committee of Parliament. Oliver Bakavomawo is Constitutional Rights and Policy Strategy Advisor at Democracy Hub. So I suppose you are clearly aware about what happened yesterday in respect of the OSP's invitation of Paul Adom Ochre, former chairman of the board of the airport company. And many did not understand what exactly was going on, but he, before he honored the invitation, spoke to did a video and told the public about why he was being invited, about a contract, and then subsequently Manasseh Azure-Awene also put out a story. And this is how Manasseh Azure-Awene's story, he and his colleagues, that's Manasseh Azure-Awene, Adjoa Adobia, Owusu, and Evans Aziamo. If you recall, these are the same people who did the investigations into the SML story. So the story begins by saying 3 days before the December 2024 elections, the Ghana Airports Company Limited awarded a revenue assurance and auditing contract to Avatex Logistics Limited, a mining and stevedoring company with no prior experience in performing this service. I'm sure you are familiar with these kind of stories. With no prior experience. This shady revenue assurance and auditing contract appeared to be backdated. For evidence points to the possibility that the contract was signed after the New Patriotic Party lost the elections in 2024. The immediate past board chairman of the company, Pollard Mortuary, as in the Ghana Airports Company Limited, did not deny the allegation by management of the company that he brought the shady company. He has also confirmed that the procurement process for this shady contract started at the board level. The managing director of the airport company, they wrote, said the company awarded the contract to Evertex because the airport company lacked internal capacity, including personnel and time to deliver the service. Check what? However, while the airport company has 1,580 employees on its payroll, information that they obtained from the Social Security and National Insurance Trust, SNIT, indicates that Evertex has only one worker. This is where the story begins. Pollard Mortuary has been saying that this is witch hunt because he has been doing work against the OSP and that is not hidden. And so this is witch hunt. So let me find out from my guest, from what they have gleaned about this situation so far, what they have to say. So this time, I think I'll begin with you, Oliver.
First of all, let's be clear that Pollard Mortuary has been invited, not in anything connecting with his journalistic practice, but in connection with the role he played as a board chairman with the company that this has come up with. We know at least from what Manasseh Azura has published that perhaps the complainant in this case is the Fourth Estate. And the Fourth Estate has done marvelous work so far in terms of some of the things that have unraveled. And so I want to commend them as well for the continuous work that they do in this regard. It is important that we understand that persons who are appointed to boards of statutory agencies are not there, well, some characterize as God's favor or whatever the reasons may be. It is a responsible and a high office or that owes significant fiduciary duties that you are expected to perform. That in the performance of that role, you can incur criminal and even civil liability for the role that you do. Now, based on the complaints, at least on the complaint that we know now public, is the OSP entitled to invite a person who was serving there as board chair and based on the full report, seems to have been instrumental in terms of bringing the company to the company, the Evertex to Airports Company? I think that the OSP is entitled to at least invite and listen to them and hear their side of the story. There's nothing irregular about the process of being so invited. And just on the basis of an invitation based on a complaint that, at least from what we have heard, discloses information that we think that some questions must be answered at least. Sorry. That anybody would then, on the basis of this, say that there's a witch hunting that's going on. So for me, I don't buy it. I think that it is significantly premature just on the basis of an invitation to then go off and try to create a media spin around this. But the work of anti-corruption agencies and of any agency is done so in the public glare. And it's done so and must expect public commentary on it. Sometimes by those who themselves have been accused in order to garner public sympathy, to be able to divert attention from the issue, or for whatever reason can be a stage to perform and get some 60 minutes of fame. I don't know what the motivation here is, but there's nothing untoward from the special prosecutor inviting anybody who a complaint has been made that concerns to come and answer questions in relation to that. If this is all the information we have, I don't think there's any more that I can say in that respect.
The story, as we're beginning to learn, as in what it is that the OSP is investigating, from perhaps the little you may have read about it, what do you have to say?
I mean, the OSP has also kind of informed us that there's ongoing investigations in respect of SML. And then we are seeing, again, the tentacles of SML extend to other agencies, which is, and based on the complaint investigation that has been done so far, just the sheer number of individuals that are affiliated with SML who have then transmogrified into another Evertex here, which is actually very routine in terms of how corruption happens in this country, the successive incorporation of different names to be able to do the same thing. So at the very least, it raises concern, I would say that in this particular case as well. And also reading the conversation in terms of how the procurement process was made, and we understand, and our understanding here is that there was another company, DevNest, that was going through the procurement process, and that which apparently had been cleared to be able to be procured for the service that is being talked about.
That's right.
Then all of a sudden, we have another company that is substituted to this. My understanding was that the MD was saying that it was the DevNest that was being procured that wrote to them and asked them to appoint somebody else. Again, that is completely irregular. You know, you can't go through the procurement process for another person. It's like me going for police recruitment, presenting my documents and say, don't give me the recruitment, take my brother instead. So these are things that warrant investigation, you know. And it seems now, and this is one of the biggest challenges of public auditing generally, that whether or not the need is significant, whether or not the company that is being proposed to come and do the work is being procured properly, it seems that there's a write-off that the PPA continues to give for so many of these entities. And that's a big concern as well that we need to look at. I understood that the NBC had promised that they were going to review and re-look at our PPA structure itself, concerns around sole sourcing even in general and things like that. And now one of the other approaches is restrictive tendering, which is ongoing. That I'm hoping that these things do not become just the OSP going after SML, but we are plugging the loopholes within the system that allows for these repetitive schemes to be played on the public purse and also on the public conscience.
Okay, so you catch your breath. We'll return and look at the matters that came up as far as the bail denial initially is concerned, because issues have been raised about that in respect of his fundamental human rights to be, admitted to bail. So, Abraham, again, reading the development, the stories, it looks like a bizarre story, but at this point, you're able to give the people who are, being investigated the benefit of the doubt, right?
Oh, yes, because these are just investigations and they have not been found guilty. Board members play a key role in decision making when it comes to companies, and they shape the direction the company must go. And so when I heard him say that, these are matters, these are matters within the purview of management, and they are not matters within the purview of the board, I said, no, you can't say that, because this fiduciary relationship will tie you in. And in any case, when you look at the entire story, one of it is that it has to do with the breach of the Procurement Act. Single source, some say sole sourcing, but I think the Act says single source. So a single source was given to a company, but it turned out that that company was substituted. Now the question is, have you breached the Procurement Act? Particularly, you are aware, most of the cases that have gone to the court on breach of Procurement Act are more or less like strict liability. As a board, are there means to show that the board accepted to do what has happened? You can't find that. And so he has questions to answer. He should stop hiding behind the fact that he has some bad blood between he and Kisi Ajabin, and confront the issues as they are. I'm aware that he's made a lot of publications against Kisi Ajabin, but is that why he was invited? The answer is no. It is also important that he knows that as a board member or a board chairman of the company, at any time in point, when the company is found wanting, because of the role that he has to play to ensure to protect the company's assets and protect the image of the company, he will be invited. So this for me is not witch hunting as he claims. This for me is calling for accountability. The matters are clear. Did you engage in a single source and it turned out that another company has been granted the opportunity to do the work. That is what Paul Adumoche should focus on and deal with. This issue of he being invited because he has a bad blood with Ajabin is a red herring, it's diversionary, and it's not dealing with the substance of the case.
I'm reading this part of the story. It says that Evertex, SML's sister company, also appeared to be dormant and was resurrected only for the airport contract. Its tax record revealed that the company has zero chargeable income for 2022, 2023, and 2024, the year it won the airport contract. Evertex paid no tax in 2022 and 2023. They also checked with the Chartered Institute of Accountants, is it? And they also confirmed that this particular company has not been licensed to do revenue assurance, and that to be able to carry out this particular job, you must have been certified by the Chartered Institute. Do these make any difference for you in the?
They are huge and they are substantial. First and foremost, what's the object of that company? We are told they are not into those areas.
Yes, so we are told that it was after they got the contract
that they then decided to...
That they went to now change their objects at the Auditor General, company, Register of Companies, to include
that one.
This particular business.
So it tells you from the word go that they lack experience in that area, because if they were into that area, it would have been part of their objective. Now, the other thing too has to do with the fact that this contract was signed after the MPP lost elections. No problem about that because the directors were still in office. But it will create some suspicion about why this company, which has no experience, which was brought in later on, which invariably was incorporated later on, because that was the new incorporation, to insert in that clause for them to be able to do that work. For me, it's a new incorporation. But for that, they couldn't have been...
change of objects.
Change of objects. Yes, change of objects.
So but that's not new
it was done after the contract was signed, an afterthought, So all this will raise questions about whether the company in itself was properly placed to engage in that work, apart from the fact that it was being favored by the way it was selected. These are matters that maybe the prosecution will use against Paul Adumoche's board. And I think that he has questions to answer, more so because of the Procurement Act, which for me was breached.
Oliver mentioned the complicity of the PPA. We find many situations where when you are sole sourcing, the presupposition is that the entity you are sole sourcing is like the only one, available to do that particular job, apart from the other reasons. But you have situations repeating themselves where the entity is not in that business, they have no prior experience, and yet they are sole sourced. And the PPA continues to approve these. When it came to the SML, it was the same situation. Their very first job in this regard was the job with the government for this revenue assurance thing. And the investigations or the report suggested that they were doing zero, and yet were in a position to earn, because they are earning a certain percentage on the revenue that is coming in. In this case, too, it's a 15%.
PPA itself must come under tight scrutiny. And I agree that sometimes, even though there's an opportunity to ratify your conduct under the PPA Act, But in a case like this, where the minimum basic requirements have not been met, which is that this company is unique and it's the only company that can provide those services, that has not been met. To find the PPA okaying it, and I don't know whether in this matter they actually okayed it. I'm not sure of that. I didn't read that. But if this has been okayed by PPA, PPA itself must come under heavy scrutiny. And they may also be contributing, and that I would say contributory negligence will be applied here, where they have also contributed to some of the things that we are seeing in the breach of the Procurement Act. And they should be the last. And I think that the PPA board must also begin to look inwards and see whether some of these things that they do is helping us.
Honorable, those who did the story, they spoke to experts who reviewed the whole situation. And one of them, a foremost procurement practitioner, Obena Atabedu, and he said that the PPA and the airport company violated the public procurement law in the Evertex contract. He said Evertex was not licensed to perform an audit and revenue assurance and should have outrightly been disqualified. So he should not have been awarded the contract. Will not be the first time you are hearing things like this.
Yes, and we are all interested in matters of propriety when it comes to the governance of our country. And I come from the inclination that once you take a public office, it comes with accountability. It moves contemporaneously. And so the process is going on as it is, the invitation of the board chairman. As I sit here, I will not hasten to say that it is in a bad taste. Except that we have expectation that the procedure that we know to accompany processes like this should be adhered to. Also paying attention to, all the courtesies and rights that must be accorded to people who appear before the OSP and other.
We'll talk about that. I want us to look at what we are being apprised of as regards the substance of what is going on before we look at the question of the invitation turned to arrest and then the detention. Right.
Yes. So if it is as we have heard it to be, because it's an emerging story, I'm a bit hesitant in going so much to make certain emphatic, pronouncements on the merit. But we have heard, some of these comments that has come. And as I indicated, we are interested in getting to know what the issues are so that we can find solutions to them. If, issues of culpability in respect of certain individuals also emerge, then the law can, of course, take its course. I'm more particularly interested because these processes will somehow give us the role play and the dichotomy even in terms of duties between the board and then management, because it looks like the argument that has come from both sides borders on who is in charge of what. So if I'm a board chairman, what is my role? And as an individual within the corporate board, at what time do I inherit? At what time do I come into culpability in respect of an action that may have been taken, in that corporate, environment? And at what time can we say that, as for these things, they are within the remit of management? I'm interested in all these things. So as the issues unfold, And as the OSP does its work, we will follow. More lights will be shed on these so that we can all come to, a very emphatic
When you hear
conclusion.
that the airport companies point for bringing in this company was that it lacked the internal capacity, including personnel, to be able to deliver this kind of service. And they show you their investigations that the airport company has 1,580, and this company is just one person.
That would be worrying. Conspicuously, that would be a serious issue to contend with. I will see again that it is still very early days for me to stick my neck out and make some emphatic. But as the issues unfold.
You read the Fourth Estate story?
Yes.
You read it?
Yes.
Okay, you saw that they attached documentation to it?
Yes.
Okay. Yes. You are unable to, on the basis of that story at least, make a reasonable commentary about what you think
we all do. On the face of it, you could come to a certain conclusion of wrongdoing. Wrongdoing, the next question will be on whose part? When we find something which has been done wrong, on whose part can we affix, that blame and responsibility? The issue also has to do with times where corporate bodies may also deceive boards. That is also one angle which, comes to play. But at any point in time that we are able to clearly see that whatever was put before the board was a matter that, was clear and that nothing was hidden from the board, such that the board could have come to a wise, conclusion. But then it chose to go other way, which has occasioned some loss to the state. Then, of course, we are all interested in, affixing the blame at the right place and seeking the right recompense for the state. At this point, as citizens, as stakeholders in this country, that is what we should all be looking at.
Okay. Yes, Vicky Bright.
Yes, I'm just deeply troubled by the frequency with which our procurement laws are just, completely ignored or breached with zero consequence most of the time, and by our SOEs. And it's becoming so blasé that people kind of just ignore it. It's become like a tick box. So we need to go back to the drawing board and strengthen, our procurement body, the public procurement, the PPA, by punishing people who flout these rules. This situation that we have here, there's still an investigation going on, so we can't come to any firm conclusions. But looking at the story that the Fourth Estate has put out, it is clear that even a basic level of due diligence was just not done. The minimum was not done. It seems from the facts that we have so far that the board was ineffective and senior management made some serious mistakes. So it calls into question their competence. I don't know whether they had a board charter or not, but how can you have one company present to you and then write on the say-so of a private company that you should change the company that presented to you? You should exchange it with another company and you say, okay. Who is driving who here? you know, in colloquial parlance, we'll say, you know, is the dog wagging the tail or the tail wagging the dog? You know, which is which? Because, and if that company, DevNest, is telling you that they are not competent to do the job, but then you, the board, have actually passed them as the competent company to do the board, what does that say about you? I mean, what presentation did they make that got you so convinced that these guys should not only be not shortlisted or anything, but they should actually be sole sourced? And then you have them calling your own judgment and competence into being as a board. It's serious. So who are the people on the board? Who were the people on the board? So, you know, and then we've been through no license, you know, and then the staffing issues. You say you don't have the capacity, yet you have 9 dedicated staff, 8 full-time and 1 national service staff. They only have 1. PPA also didn't bother going through even at the very minimum, the criteria for sole sourcing. You know, it's very clear. It's not something that's supposed to be done in this kind of way. And then the agreement also, our understanding is that the agreement was signed without even the CVs or the employees, the would-be employees or the team members. And what the person, the DevNest guy who presented, the CEO, is also one of the people providing the. I mean, it's a total mess. So it's very troubling, and you know, it's a real case study of.
Let me just read this portion of the story and ask you this question. The executive director for the West Africa. For the Africa Center for Energy Policy, Ben Boachi, describes the situation as bizarre. And they say that our investigations reveal that the email address on the website of Evertex, evertel@ghana.com, is the same as the email address on the website of Evans Timbers Limited, the parent company of SML. A search at the Office of the Registrar of Companies also revealed that SML and Evertex, the mining company that won the airport contract, have the same beneficial owner, Evans Edusei. In fact, Evans Edusei is both the CEO of SML and Evertex. He signed a contract with the Ghana Airports Company. The list of employees submitted by Evertex to the Ghana Airports Company to execute its contract contains the names of notable SML employees and managers. Apart from SML's CEO, SML's head of engineering, Hamdan Abubakar, is on the Evertex list. SML's head of IT, Prince Opoku Sapong, is also on the list to perform the Evertex contract at the airport. A former head of legal at the GRA, Philip Jude Mensah, now an SML employee, witnessed the Evertex contract with the Ghana Airports Company. He is on the Evertex list, together with a former commissioner of customs and now general manager of SML, Isaac Krensel. In essence, SML, which now appears like a post-retirement destination for top GRA employees, sneaked to the airport disguised as Evertex. How Ben Boachi's comments then says, it clearly tells you that they themselves, that's SML, admit that they have been doing things wrong and they don't have the confidence to go bidding or working with the same company. The question is, from the board through PPA and all other places, is it your expectation that they would have flagged the company and say, oh, you are the same person, SML, you brought us some trouble. The president, then Akufo-Addo, commissioned some, audits, and it led to termination of some of your contracts because you are not doing things well. So how is it possible that they could just go through without them being flagged?
Samson, I'm laughing because it's a joke. I mean, this is what I'm saying, that clearly the management was not competent, the board was ineffective, and there was a total breakdown. SML is taking us for a ride. We've become a huge gravy train, and they are just riding that train, you know, from all that we see, all that we've heard about them. And it needs to be stopped. A basic, very, very, very basic level of due diligence would have uncovered. I mean, and I'm talking basic, email, just an email without even going to Registrar General. That should have triggered something. You know, so if we are not even picking that up, then what are we doing? This is Ghana Airports Company Limited. It's a very serious organization, you know, with all sorts of security, you know, installations in there. For our country, it's like running, you know, a British airport authority running Heathrow and Gatwick or something.
So how does that happen? Oliver, they say they have this expertise, and a journalist finds out that they completely don't have. In fact, this is not their job. It takes a journalist to check with regulatory, you know, institutions to find that they're actually not licensed. They say they have this X number of people to do the work. They have the capacity. And it takes a journalist to check and see the checking the journalist is doing. The journalist is doing them with state authority, state agencies. And is finding at each point that they are not who they say they are. They belatedly go and now, you know, register an object to say that we are able to do this job.
Shocking.
You know, one of the things I find repetitive in this case, now we're interested to see whether there was a needs and assessment made by the airports company that said that we needed this revenue mobilization or revenue assurance, or that the initiative came from the company. Because you remember in the SML situation, the GRA said, no, in fact, we didn't call for this. And so it is there's a systemic, inorganic need generated for state agencies, where they themselves have not assessed that they need a particular help in an area. Then somebody comes up with a scheme and says that we are coming to do this for you. And then that goes through a process, and then people are selected. Now, if you have in fact done any work as a company to be able to evaluate a need, you will then be able to determine, in fact, what it is you consider to have been losing in the process before you make a decision to procure. Now, even my law firm has gone on and seen tenders and applied for. The extensive number of documents that are demanded from your tax clearance certificate, labor certificate, incorporation documents, who are the shareholders, who are the beneficial owners, all this information is part of the process. This is for even when it's a competitive process, how much more when you are single sourcing the company to do this. So it is not an excuse to say, well, we should have and we failed to do, because that's also an admission of criminal liability and civil liability in some regard. But also if you tell us that you in fact received this document, then it raises significant questions about your competence for being able to hold those office. I know that certain individuals are already asking questions of the MD of the company who continues to be at post. I think that those are justified questions to be asked in the context of what we are discovering. My concern...
But the MD has terminated the contract now.
It is not enough. You see, it is not enough now that this has come into light, particularly even when there were allegations of backdating contractual documents. This would not have gone through without the MD knowing about them. So when this comes up and you say that we have terminated the contract, it doesn't
the story
cure
says
the question.
Multiple sources at the Ghana Airport Company said the board chairman, Paul Adumochiri, who had used his TV program to defend SML, brought Evertex. So are you able to see that? I don't even see how they bring him in, even if he has presided over board meetings. And how does this make him complicit? That if in fact he brought the
company in. You know, first of all, on the question of who brought the company in and the MD's role, and I'll come to this, that it is not sufficient for a board, and you are CEO now, that a board would say that we have gone to find somebody and that we have decided this person must be awarded contract, and you would have objections to it, and those objections will not be registered. At the end of the day, the contract is signed in the name of you, the MD, or whatever is signed. So there's no excusing of liability in respect of what overwhelming role the company board played in the process. Now, if Paul brought the company in, the question of the level of influence that he exercised in influencing the getting of the contract to the person in breach of those laws is a question of scrutiny that should be done. So it's not necessarily the fact that the board chair introduced the company, but the level of influence he brought and his own involvement in the breach of laws that would have checked as to whether or not the company was better performing its functions or whether met requirements is what will be under scrutiny. Because I must say this, as a member of a board, if there's an issue that comes up in terms of how the board operates, and then you know of a company or companies that are doing particular work in an industry, you are entitled as a board to invite them to do a presentation before you for the board to make a decision. That is not the wrong or what is being questioned in this regard. The regard is the question. What is being questioned is, first of all, in fact, what he obscured or did not disclose as part of his fiduciary duties to the company, in knowing what extent of information or how do you know them. Because when I read the investigation, there was a suggestion that he had denied, in fact, being the one that brought the company to them. Again, this is based on the investigation itself. So what disclosures were made and how you got to know them and how you brought them in, it's all questions that I'm sure that would have been the interest to the OSP in this conversation.
If there's no an approval by PPA and the rest, there won't be this contract.
Yeah.
So where is the board chair in the picture? I don't see his liability.
So this question about when the PPA comes in and approves the process, whether or not it excuses liability is also a question that we have to be able to consider to what extent. Because also, I am not certain what information was disclosed to the PPA for it to be able to obtain its approval. Those are things that I think the normal process of the investigation process as the OSP is doing would be able to clarify in what direction to be able to go.
But the PPA must also have a responsibility to check to see that this company is qualified, they are who they say they are, and so on.
In fact, and it is not new in this case that the PPA itself have been involved in violations of law. In fact, we have a former PPA boss who is currently before the courts on criminal charges. But in respect of the board chair, the role that the board chair played in the process is what is being scrutinized. So it is not sufficient to say that after I did this, PPA approved. But what role is specifically played in the process too, which also with regard to the substitution of a company for another and your own disclosures that you are required by law to make.
Does it not matter that the company that gets substituted also writes a letter, and Manasseh and his friends have shown the letter that they are saying, yeah, we were supposed to do it, but we felt that somebody else should do it?
No, it doesn't matter at all. It is a different thing if the company that is procured changes its own name. Because this is in law, these are two different entities. Irrespective of the beneficial ownership or whatever it is, that other company must go through the same scrutiny and process. Whether or not they also have they have complied with tax obligations, whether they have done all these things, these are things that must independently be interrogated. So there's no, even in fact in our laws, there's no process by which one company writes and says, give my job to another person. Like, it is not even fathomable for that to be the situation. In fact, for me, this is the first time I'm seeing this happen.
Okay. They say that this first company that was engaged, they appeared before the board on 3 occasions. The last appearance was on August 16, 2024, during which fees for the audit and revenue assurance services were agreed. The company, the board agreed, should be paid 16.5% of any excess revenue above the airport company's benchmarked revenue projections for its services. He sits at the board and supervises what the board, as it were, moderates the board's discussion. Vicky, because you wanted to come in, I'm still trying to appreciate what he would have done wrong, for which he will be the focus. He will be part of those who are being investigated.
I'm also struggling having the same challenge because introducing someone per se is not an offense, but I guess it's how far you take that introduction and how complicit you are in maybe turning things around. In this particular case, DevNest, which is the company that appeared before the board 3 times and was then subsequently allowed to qualified as being the sole source company for this job, wrote. So if they are telling you they can't do the job, does that not immediately, isn't that a red flag?
Yeah.
And then the people who can't do the job are recommending another company. So at that point, even if you hadn't done any due diligence at all, that should definitely be a point at which you say, okay, now, where is this company? What is this company? Bring all your documents and dot your I's and cross your T's. And if you're talking about the board, then you should look at the whole membership of the board.
Right.
There has to be a reason why one board person, whether it's the board chairman or another board member, is being singled out. And I guess we will find out in due course why the OSP has singled Paul Adumotri out.
You see, as a board member, let alone a board chairman, you are a gatekeeper. You must protect the interests of the company. So when that company that won the contract, Devness, wrote to the company, referring its activities to another company or transferring its activity to another company, that is the time that Paul and his board should have exercise their responsibility to keep the gate. At that point, they should have truncated that contract, terminated it, and then look for that other person to also come and do a presentation. Because that would have been the basis upon which they will now take them on board. But that wasn't done. So that responsibility of failing to keep the gate is where the board, and I agree, is the board. But we need to know why it's only Paul Adom.
Okay. But in fact, we can't say that it's only Paul Adom. I just want to be clear.
It's the board.
That we know that Paul has advertised his invitation. That as to whether or not the OSP is looking to talk to everybody on the board, we don't know that in fact.
They have told us that he's not the only one.
Yeah.
The OSP says he's not the only one.
On the board or just generally in the company?
We know they've named other people who are part of. Whether they are board, I think they are not part of the board. Yeah. Okay. So as I understand it, the fourth estate is not the complainant in this case. It does appear that the OSP in its own investigations around SML chanced upon this and began to do its work. That's the impression I'm getting. How about the process? Let's begin with you, because you are concerned about he being invited.
Yes.
And he says, you want me on a Thursday afternoon. My lawyers are in a Kumasi. Can you allow us to come on Monday? And I'll be frank with you. If a client of mine gets invited to police on a Thursday or Friday, I try to negotiate so they don't go because things can happen.
Yes. So just a bit on the issue we just left off. I can see that we are all struggling to know the legal vehicle that makes a board chairman solely responsible for.
We're all not struggling. Oliver was very clear about it. I think Vicky did, but posted a caveat.
So that
and of course, Abraham said, you are a gatekeeper.
Yeah.
So we are not all struggling.
So that the responsibility is placed at the doorstep of only the board chairman.
In this case, not only the board chairman.
But we've not heard any other board member who has been invited. In fact, not even the managing director who actually signed these documents for and on behalf. So maybe I may just have to. Maybe I may just have to restrain myself.
As we understand, the managing director is also appearing. The OSP, I think that's on Monday, rather.
Yes, exactly.
Very well. Go on Monday.
Yeah.
Very well. Now to the
but they have clarified that she's being invited, but she is not a suspect. I think I saw a clarity like that.
Oh, they said that?
Yeah, I think
she's invited as an interested party.
That's also an issue to look at. That's also an issue to look at.
That's interesting because she signed.
Yes, she did.
Yeah.
And she gave the directions, award the contract.
Yeah. So it's about the procedural matters that you have concerns about. So we do that very quickly because our time is almost up.
Of late, attending the invitation of investigative and security agencies has become a problem for lawyers and invitees, accused persons, so to speak. And it is because over time, certain conduct is more or less crystallizing into the state of affair. And for which reason, lawyers are also very apprehensive when on certain days at certain times when your clients are invited, you become very uncomfortable. In fact, I think
because bail is discretionary.
It is.
Even though we are entitled to it, it is discretionary. So the one who is going to give it may not give it, and they will not break any law.
That is true. That is true. And I think that at this stage of our democracy and even our legal system, I think we've come a very long way, such that if a jurisprudence that is as old as time, like the grant of bail, which is also one of the commonest applications you will find across all the courts in the country, litany of pronouncements on it, and of course with the incremental additions
bring your own landed property.
Yes.
They don't put any value on it. That is the problem.
Yes, I think that is new to our jurisprudence in terms of the grant.
Is that new to you?
Yes.
Oliver, is that new to you?
The requirement to produce property in your own name.
Yes.
Yes, it is.
It is.
I think so.
Okay.
Because I'd say that, the bail process is designed to have sureties in the process so that if you're not able to meet it, somebody else can. But then to arrest anybody without knowledge of what they can produce.
Self-recognizance bail.
Yes, self-recognizance bail does not require you to produce property in your own name. Okay, so I think it's new. But I think that particularly in this context, that I think that the OSP was entitled to his 48 hours. And his decision within the context of that 48 hours to release Paul on bail was his decision to make within the context of that. Now, he then could, because the law is that you can release the person with or without conditions. He determined that these were the conditions that were to be able to produce. His determination that the condition was demanding is that the property has to be in Paul Adumotri's name, for me, was a strange one. But the fact of the conditions of bail itself is not entirely new.
Okay.
I have the instances where I've seen the demand for people to produce government workers. Yeah. In Nigeria, this has been found unconstitutional. We continue to do this in Ghana. So there's a bigger questions of reform of bail conditions generally.
Atabedu, we mentioned earlier, says that the procurement expert says that this issue has multi-facets of challenges. One, violation of pre-qualification, procurement methods, and engagement of consultants, provisions of 663. Contract law, several vitiating factors come to play, i.e. capacity to contract, fraudulent misrepresentation, corporate governance. There is obviously undue influence and the adherence to acceptable practices. Institutional capacity, both the boards of PPA and GACL were negligent and incompetent, and they must collectively be held accountable. I'm sorry, but we had extra time, but we have use that extra time. Thank you, gentlemen and lady. Victoria Bright is international corporate lawyer and entrepreneur. Paul Admotri sent me a message. It's quite very tall, but he's trying to explain that there's a lot of loopholes that you need these assurance methods to plug at the airport. And from the message, he suggests that if we're able to do this and do it well, the money we get from this place alone may be the reason we may not need to go anywhere borrowing money. So that's just to say, and that some journalists and other individuals get sponsored to work against this kind of, tightening the loopholes, and we should be careful about that. Okay, Abraham Amaleba is Director General of the NRSA and member of NDC Legal and Communication Team. Kwabena Boateng is MP Ejuso and Deputy Ranking Security and Intelligence Committee of Parliament. Oliver Bakavomo is Constitutional Rights and Policy Strategy Advisor, Democracy Hub. They are doing a protest on the Galamsey menace in September. The date again is
21st.
I'll join because this existential threat, we must overcome it. This has been Newsfile. I'm Samson Ladia Yanini. Have a good afternoon.
MTN.
Bank of Africa, as strong as a group, as close as a partner.
Where Duraplas goes, water flows.
PS Industries has introduced a new roofing system known as ColorLink Plus.
Flamingo paint, simply superior. Syntax tank, are you strong? Are you tough?
Cherry Tree Properties. We develop spaces as though we were going to occupy them.
Still, Misaka, and Nemum was a summer brabo, and it can afford Swabrabo.
Misaka pensions, Caro.
Misaka or the Sika. Misaka insurance.
Misaka loan.
Momo Fogusuri echumaden, the aboye nyina ye sika ho ban. Se MTN, ana momo jumayeni befrewa, or the 0244 300,000 ene befrew. Ne numpo orin bitsaw one-time password, ana se upin code. Enti wonso ye wa femu die na ma weni na ho na wonsa enka omo.
For decades, we have helped businesses connect with their trade partners all over the globe. From Ghana to Burkina Faso, Côte d'Ivoire, Benin, Togo, Senegal, China, Morocco, France, Netherlands, and many other countries. We have made it possible to bring Ghana to the world. We have brought small and medium businesses closer to their customers across the regions in Ghana with our SME support facilities. We have brought relief and smiles to the faces of families with our employee personal loans. With our cutting-edge technology and digital support, we take the burden of complex thinking off you, making life simple. That is who we are, as close as a partner. Bank of Africa. We are indeed the African bank with the global reach.
When it comes to your kitchen, don't settle. At Safety and Home Solutions, we combine European-made aesthetics with premium materials built to last. Every cabinet, drawer, and finish is crafted for both beauty and durability, made to handle real life every day. What makes us different? We custom design your kitchen to fit the exact space. No guesswork, no one-size-fits-all, just clean lines, smart storage, and the layout just fits how you live. And once you approve the design, installation is smooth and fast. No delays, no stress. Our in-house team handles everything with precision and care. Visit us at Safety and Home Solutions Kitchens on Spintex Road opposite the DBLA Ultra Center.